Good evening, chat. Hello. How are you guys doing tonight? And why are we still what the hell happened here? Hold on. Hold on. Did we fix that? There we go. There we go. Anyways, welcome, welcome, welcome. It's Saturday night. Welcome to the show. Welcome to the show. I am Sean, also known as potentially criminal. Tonight we're gonna be talking about Russell Greer, and it seems like are we finally getting to the beginning of the end, or at least the idea that the tide is slowly starting to turn? I mean, That's that's something I think we should phrase here because is it the beginning of the end or the end of the beginning? I don't know. I don't know. To quote the great Winston Churchill, which part are we at? The end of the beginning or the beginning of the end? I definitely think we're at the end of the beginning. There's still a lot more. There's still a lot more baseball to be played, but I think we're starting to see things that are good and that are positive towards how this will finally resolve. How this will finally resolve. If you guys like my new sweater 2.0, I was like, you need something less Unabombery. So this is a little less Unabombery, but it's also nice and warm. So, and it was cold today out there. First in the morning, it was like 60 some degrees, and then it rained a little bit, and the temperature dropped like 20 degrees. I'm like, oof, it was a rough day, rough day. So, yeah, I know you guys had mentioned it last night and before. I actually got to do got to be a judge for the American Mock Trial Association, which is something I remember learning about in college, but I never got the chance to do. And if you guys don't know what it is, it's a organization where colleges put together teams, and they show up and they argue generally some like civil case that's been made up with it. And it's interesting because these people are undergrads, so they're not law students or anything like that. And it's this contained ecosystem of facts, information, and also like they have their own case law that they get to use, and it's a set amount of case law. You don't get to go outside of it. You can't. You're stuck with what you have, and it's just all kinds of students are involved in it. And the thing is, like when you have your witnesses, for example, um, in law school, your mock trial stuff, witnesses are like regular people, kind of like hired off the street to come in and testify. So they're what you get, just like real life. But in this mock trial situation for the undergrads, they actually have a team, and part of their team are the witnesses. And these people, it's about like their presentation style. Do they come across as somebody who's meant to be like an old lady or some blue collar guy working in a factory? Do they dress and act like that person? Like it's an entire thing. So, even if you're just in the law, but you could be like a theater person or somebody in, performances and whatnot. There's an entire range of things there. And I never really got to do anything with it before, but judging it, it was very fun. It was a lot of fun. These schools were really talented. It was creepy seeing a bunch of people doing this, and I'm like, holy shit, they were all born after 9/11 because they definitely all were. But it was a lot of fun. It was a lot of fun. Good luck out there to Stetson. Because I got to judge two trials. You do three. The prosecution does it, or the plaintiffs open, defense opens. The plaintiffs do three witnesses. The defense does three witnesses, and then they have closings. So, and good luck to Stetson University, the University of Maryland at College Park, because apparently there's a couple of University of Maryland teams that made it in. The Harvard, I think they call themselves B team, but they're like team 2. I don't think they're the B team. They were very good. And Northwestern. Good luck to all those groups out there. I doubt anybody watched this because no one ran up to me and was like, "Are you the fat man?" Which I was like, God, that's going to be awkward if that happens. But it didn't happen. Did not happen. So I'm glad. I'm glad. But if you're out there, guys, enjoy yourselves and good luck. Uh, all right. Let's see here. Yeah, it wasn't bad. It was like 3 hours every time. So last night was late. Last night was late. God, I was like, I thought this would be a little shorter, but I'm like, fuck, trying to get out of there. The other problem was trying to get out of from around the courthouse when there's like 700 people Ubering cars and shit because they're all from all over the country. It was a mess getting out of the area. It was a mess getting out of the area, but I enjoyed it. I enjoyed it overall. I would definitely do it again. I would definitely do it again. So let's see here. I know the Fat Man is upside down. That was some strong fucking gravity. Let me tell you what. I probably wore it out. Let's see here. Where are you guys? Yes, I'm Mr. Rogers' fatter, more heavily armed son. Yes. Also a little more anti-Semitic. This way up says, I can imagine Sean. It says, overruled Safa. No, actually, it was very interesting because part of the grading, you don't necessarily grade them on. It's about how they responded to things and how they presented. Because the case could be the people who wrote the case up that are in the organization, it's set up by attorneys. And it's meant to be a case where it's like it could go either way. And this time it was like a guy was working at a bowling, like a guy got sucked into the pin machine at a bowling alley and it killed him. And then was it negligence by the employer, or was the guy, was there contributory negligence? And was the guy part of the reason why he died? Was it his fault? So, and this is one of those ones where it's like a 50-50 case. Like, I could argue it either way and I'd be like, yeah, it works. But there's so many different ways you can argue it. It was really, really cool. And then when it came to like the objections, you could make the objection one way or another. And these guys, obviously it's all rehearsed and they pre-plan everything. But they war game it out that if we get objected here, here. And these teams, like, I was not the presiding judge. The way they do it is there's 4 judges that judge the rounds. Then there's a judge who actually is the presiding judge. I've never had any experience of this before. So I didn't want to do that because I don't know what the hell I'm doing. There were multiple people. I mean, it was a rooms full of lawyers. But it was also a room full of lawyers, but also people who had done this, like, AMTA thing, the American Mock Trial Association stuff, as an undergrad, but then they didn't want to go to law school. They just enjoyed doing the thing. So they have a lot of experience at it. Like, yesterday, that was one of our people, and then today was a girl. She's a law clerk, some federal judge somewhere. And she did the whole AMTA thing through undergrad and then went to law school. So she understood it. But people that have experience doing it, I would feel comfortable going forward and doing it. But if you sustain an objection or overrule it, these kids, they would utilize, part of the thing is you let them make their arguments. And then if you rule, they immediately move on. If you got the green light, they go ahead. If you say sustain, they immediately pivot and go another way. I was very, very impressed. Very impressed. I go up to them. I'm like, do you know who Pipkin Pippa is? Yes. Yes. Can I get a QRD on the protest today? I didn't even know there were protests. Like I said, I've been out having fun, so I didn't even know, guys. Sorry. Fatty Caddy says, has Russell's dick finally been stomped? No. Like, there's finally pushback from the court is how I'm gonna phrase it. That's the TLDR. Let me see here. What else are you guys talking about? Are you guys talking about it's a Final Destination case? Yes. Yeah. Oh my God. Jesus Christ, honey. Uh-oh. I guess I have a. All right, chat. Get your things in. Hi, buddy. Come here. She's scooping food, so he's like, oh no. Anyways, look, guys, apparently we have fucking sweaters. Have you been waiting for me to wear this? Babe. 2.0. Oi! 2.0. Have you been waiting for me to wear this? Have you been saving this until I wore my sweater? Oh my God, you people. Mwah. Woodish Clyde, you're such a strapping young lad. You look very handsome. Uh-oh, he's like, there's food. I want the food. Do you want me to put you down, Bubba? I'll set you on the ground. Here you go. Enjoy your food, buddy. All right. So let me see here. Did I bring Trump with me? No. No. Yes, Stabby is Acerthorn starting to run the hurdles too. And the problem is with Acerthorn, people have asked me to cover, and I talked with Kratosis. I'm gonna start like maybe his lawsuit because it's interesting, but there's so many of them. The ones that get Sid Alpha and Imperial Salt, like there's so many lawsuits with Acerthorn. It's hard to really do them just because he's such a spaz, such a spaz. Oh, let's see here. What else? Did you order Kirsch's cup from Gamer Subs? No, I don't. I didn't know there was a cup. What is hers like? Did she have a cup with like a pair of big tits on it? Oh, so anyways, chat, that is kind of what we did yesterday. I had a lot of fun. I did it this morning as well. And yeah, it was just super fucking cool. It was a lot of fun. It was a lot of fun. And the neat thing is, today was round 2, and it's the exact same case. But the way it works is you have to try both sides of it. So they did really good. They did really good. All right. All right. So we are moving on. Enough talking about what I did and the fun I had. Let's get into the fun of this. And this is the Russell Greer situation. Chad, if you remember, Russell Greer is suing the farms because he's a tard. But he's trying to sue them under this obnoxious theory of contributory copyright infringement, meaning that, Null, Joshua Connor Moon, the chairman of the Kiwi Farms, basically enabled and encouraged parties to infringe upon Russell Greer's songs, which I assume at this point are probably made on AI. I've had thoughts about this, that he probably used AI to make these songs about Taylor Swift and other things that are out there. Also, his book about how I sued Taylor Swift and became known as like a crazy vexatious litigant. They were put on a Google Drive somewhere, and a link was put on the farms, and Russell is now blaming the farms for the infringement. So that is where we were. And guys, normally, like I've been starting to do these where we go in chronological order. I think it's better if we kind of have a topic and run that topic out, and then another set of motions for another topic, and boom, 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 boom. I think that's going to be easier. Also, this should be quicker. We don't have as much stuff. I'm trying to limit it to a month max because there's just so much crap that gets filed where there's problems here. Oh, Nico says the songs are from Fiverr. I mean, he says that, but I don't know if that's true. He says that, but I don't know if he's true about that. It would be even funnier if the guy on Fiverr just ran it through AI and gave it to Russell. That would be the best part. Remember, Russell says these are from there, but I don't know if that's true. It wouldn't surprise me if there's a lie there. But I really hope if it really was done by a guy in Fiverr, the guy just was like, AI, here you go. So, yeah. Fiverr laundered AI sounds likely. Yeah, and that's what I mean. Like, ultimately, at the end of the day, like, I know he says he paid for him, but really, did he? So, oh, Jesus Christ. Somebody says, check my DMs. Oh, no. I'm not worried. I don't know if I like this. Oh, wow. This is actually kind of impressive. I don't know what AI filter mode this is. Here, but yeah, here you go. For once, the AI cartoon drew me pretty fat, which is good. Although it looks like Rush Limbaugh's in the background. Like a Rush Limbaugh and Hank Hill. I sell conservatism, and conservatism supplies. Is this Ghibli? Because it looks a lot more realistic than Ghibli. But Clyde looks great. He's like, puts me down. Okay. Well, there we go. Okay. All right. We're going to move on, chat. We are going to move on. Now, when we last left off, Russell Greer had been trying to get an opportunity to extend time because it's been so hard being Russell Greer. It's because Russell Greer is a big old tard. He wants more and more opportunities and time to do stuff. So this is kind of where things left off last, if you guys don't remember. And we're going to kind of just, previously on the drooling of the Russells, what happened. So we're going to go through this a little quicker here. So they point out, the whole case that's gone on here. And they point out that what Russell has done at this point is basically just obstructed, because it's clear Russell doesn't really know what he's doing. And this is as far, I think, as any case Russell Greer has ever had at this point. He's never been able to survive this long. Because remember, he got dismissed initially. The Court of Appeals, the 10th Circuit, said, nope, it's got to come back. We went down to Florida, and now we're here. So we're in discovery mode. So he survived the initial motion to dismiss, at least for now. But Russell's never gotten this far, so you don't know what to do. Like a good lol cow, he's kind of stuck with what do I do with the thing that I've done? And Russell is starting to run into the issue of, there's not much more you can do here. These are the discovery problems that are starting to build up for Russell. And, Matthew Hardin, and I will tell you guys after we get to the end of this, Matthew Hardin called me and he was on the verge of tears. Like he was telling me, he was like, Sean, do I just take my law license and light it on fire? Russell's going to sanction me. And I had to talk him off the cliff. But I think I had to steal his heart. And steal his spine. But I think he's got it now. He's going to be strong, and he will see it through to the end, chat. But no, these are the times that try men's souls. Matthew Hardin he's at his Valley Forge right now. He's having his Valley Forge moment. But I think he'll come out of this even stronger. So they talk about here, there are things here where Russell Greer failed to respond to a series of motions, in this case, when it was transferred to Florida. He promised he wouldn't let it happen again. He promised. And he would be attentive to his obligations. Yet in the meantime, he's routinely violated deadlines to comply with the orders of the court. And excusable neglect has become his watchword. Yes. Yes, the myopia of excusable neglect, chat. We're just going to start kit bashing things here. The myopia of excusable neglect. They point out he's refused to comply with each and every discovery request sent by him. And now the attempts to justify the failures responding to the motion to compel. And they said that Russell can't be allowed to benefit from this. And Russell wants to not be sanctioned for the discovery issues. So as we go through this, we start looking at that. And then what do we start looking at here for Russell? It starts to get funny. Russell is just acting like a fucking loon, and there are so many problems here. And if you guys don't remember Russell Greer's book it's Why I Sued Taylor Swift. Now I became falsely known as frivolous, litigious, and crazy. I didn't remember exactly what it was. It was just really retarded. So there we go. But they point out here that he doesn't show all the court filings they've asked for. They requested all legal filings he made, and he's like, I don't have them anymore. They refuse to provide even a single document in response to the document productions. He claimed he had lost the request for production entirely. Although if it's electronic, you can, and served email-wise, you can get them. Like, it's not hard. You can get them. So I don't understand why he's losing things, but okay. He objected to the request. He objected, and this is the thing. Russell didn't say, I don't have the documents, because he already promised he had them. He asserted the request was irrelevant and that producing all of his voluminous pro se filings nationwide would be an undue burden. And he said later he had a document he was happy to provide, the restraining order that he filed against Null in Utah. Yet he never provided the document he was purported happy to provide. So we don't have everything he wants to do. And we're not going to go through the standards of review again, guys. These are all the same things again about sanctions and about disfavoring the motion for consideration. That is said, though, and I like this quote. We covered it last time. It's from Judge Gorsuch, which is now Justice Gorsuch. When he was on the 10th Circuit, he says, there is a thing as discovery karma. Discovery misconduct may be seen as tactically advantageous at first, but just as our good and bad deeds tend to catch up with us, so do discovery machinations. So when you start fucking around, it eventually catches up. When you fuck around, you do find out. That is how this works. And sadly for Russell, he has not found out yet, but I think he's going to be going to in the near future. So Russell, when we talk about Russell Greer argued there was new evidence where he says he finds out he didn't have the document or there had been an unexplained error in the order. But even then, the new evidence is entirely fabricated and his repeat inattentiveness to the deadlines do not render the judgment's made in his absence unjust. He had the opportunity to fix all the arguments he seeks to raise in a timely manner, and he didn't do it. And remember, if you don't raise things timely, they're deemed waived. And we go through this and go through this and go through this, and once again, they are having all kinds of problems. They once again address the whole idea of Russell demanding to explain who Jim is. As we get through this, and we talked about all the different things that Russell did here, and ultimately the courts were not supposed to reconsider the motion that Russell filed, and that is kind of the crux of everything. Every time something happens, Russell's like, please, as Noel said very eloquently, I think it's very funny because now I think it in my head when I'm dealing with motions, even from opposing counsel. A motion undo the thing that already happened. Which is funny because, like, I'm in my head. I'm like, I've done right now. I'm like, I'm typing out. I'm sitting here just. I'm typing out a motion to undo the thing that just happened, which is very funny. It's very appropriate. It's very appropriate. So from here, Russell had already been sanctioned. He got sanctioned $1,000. If you guys remember, Matthew Hardin submitted a $5,500 bill, and for some reason, the judge parsed it down because apparently the law doesn't fucking apply. He parsed it down to $1,000, and then the court offset the $225 that Noel owes Russell Greer from the appeal against the $1,000, so Russell owes about $774.75. Well, Russell went ahead and did the thing everybody thought he was going to do. And see, Russell, I blocked it out, so you're okay. No one's going to see your address. I know it's so stawy, but the Kiwi stalkers will not find you. I promise. This is filed, on the 11th, and this is Russell's attempt at he wants to appeal the sanctions. And you're like, wow, is this really going to happen the way I think it is? Yes. So he's seeking a memorandum for a bonded stay pending appeal. So he came in and sought a bonded stay of the monetary judgment. You guys are wondering what's a bonded stay? Well, we're going to get to that in a second. So he's been ordered back in February, he was ordered to pay $1,000. And he respectfully disagrees with the order, and he kindly asked to post a bond to stay the pending of the judgment pending appeal of the 10th Circuit. And he says the appeal would commence at the conclusion of the district court case. And that's the thing. He cannot directly appeal a sanction like that. That's not an interlocutory issue. It's not a final appealable order. You kind of have to do it at the end. There's no real, especially a sanction like this. There's other types of sanctions you might be able to get away with appealing, but something like this is not something he can appeal directly at this point, where he can go, it doesn't work that way. Now, he does cite things here, and this is his problem. Federal Rule 62D entitles a party to stay of a money judgment as a matter of right upon posting a bond. Now, this is true. If you are in a lawsuit and you lose and there's a judgment against you and you want to appeal the judgment, you have to post a bond. You know, if you post a bond, then you can appeal. Very much like we talked about with the Trump case, where the Judge Engeron was like, you know, you owe this much money to the state of New York. You owed hundreds of millions and hundreds and hundreds of millions of dollars. And he said you can only do it if you file the exact amount, bond amount, with the court. Now, there's no way, there's no insurance company, anybody who's going to underwrite like a $500 million bond like that. Eventually, Trump was able to do some finagling and legal wrangling, and they got it knocked down to a very small, like a substantially smaller amount, which could be posted. And that's how you do a bond for appeal. But this is not a monetary judgment. This is a sanction from the court, Russell. So the district courts have inherent authority in setting a supersedis bonds. And guys, that is a bond allowing through appeal. And deposit equal to the full judgment amount is not required. And that's true. But this is not a money judgment. It's a sanction. And a sanction is not the monetary judgment. So, Stephen Bunt is saying, wait, what? I thought Russell's case has no merit. I was joking. I was joking. If that didn't come across, I'm sorry. I was joking. Matthew Hardin, no, I talked to him about, like, him and I talked about other things, but he was just laughing his ass off at the way Russell's doing stuff. So no, he's not at risk. He's not at risk. I'm sorry if that came across improperly. In my inability to properly produce the correct social cues, I am sorry. All right. So this is the thing here. He's not appealing. Like, this is not the right vehicle for him. And, you know, he stated he disagrees with the court order and believes any sanction that any of his actions was small to fall under a $500 amount. Well, that's nice, Russell. You think that. And then remember, if he got $500, that $225 would knock it in half almost. He also believes the court is refusing to understand that the defendant's website is ran by a self-described insane person with no assets, whose users share the same characteristics, and that plaintiff was substantially justified, and thus no sanction should have been imposed. So once again, guys, we keep going back to this. Russell keeps going back to the farms are the hardship. There are a bunch of stalkers and meanies. That's not part of your fucking copyright case. But he keeps going back to this because that's really what Russell wants at the end of the day. Russell has already asked for Null to say, look, just remove me from the website and prevent people from talking about me, and I'll drop the lawsuit. Because that's all Russell wants. He doesn't like the attention he's getting. That's all he wants. That's all he wants. That's all he wants. That's all he wants. So, this is the problem for Russell. This is his problem here. They say because the case is not concluded, he can't simply appeal the sanction. And it's great. He actually understood that. I don't know if he was reading the farms to figure that out, but that is correct. You cannot appeal a sanction. Nor can he file an interlocutory appeal. Yeah. Therefore, he seeks the bonded stay. And he's seeking a stay of 10% of the judgment amount, which he can't do this, but he's already asking for this. You know, as previously mentioned, the 10th Circuit doesn't require a full bond amount. No, but the court can impose it. He would ask that he pay a bond that posts 10% of the judgment. And he says because he sincerely believes any bad actions of his are not $1,000 worth, it should be valued below at $500. He believes that he will have the $1,000 reversed on appeal. And C, shortly after the memorandum decision, they stipulated they would deduct the $250 from the $1,000. Notice it's $225.250, leaving the amount owed at $774.75. This deduction shows the defendants won't be hurt if the full amount is not posted in a bond. Well, then why don't you just post the $774.75, like $774.75? You could post that, Russell, but you can't because you probably don't have the money. Just say. So, lastly, it took the defendants a year to agree to pay any kind of amount they were ordered to pay, by this court. Well, because you didn't do a good job at forcing it. So only posting 10% is fitting to how they view honoring monetary judgments. You didn't do a good job at trying to compel them, Russell. There's things you could have done, but I'm not going to tell you how to have done that. He has the capability to pay the full judgment. Should the 10th Circuit rule against him, well, then post the full bond. Post the full bond. He wants to post $74.75. Dated Russell Greer pro se, my left foot. And that's his request. That's his request here, guys. This has not been ruled on yet by the court with that. So yes, this is it's Ricky Ritardo. It's Ricky Ritardo. It's Ricky Ritardo. So moving on to the other sanction issue here. Matthew Hardin came up with another response to Russell's actions here, and he's saying, we have further evidence that Russell Greer has committed sanctionable conduct, and we want you to understand that. Remember, this is a thing here, a memorandum of law in furtherance in support of the sanctions. So not only this, but they're explaining why you can do it. So the court, anyways, the defendants agree with the motion for sanctions, pointing out two materially false statements that he made to this court when the case was pending in Northern Florida. And because Russell never withdrew them, on February 20th, they filed their motion for sanctions. Now, Russell's immediate response was to threaten bar discipline action against Matthew Hardin. And then it says, Mr. Greer eventually calmed down enough to file an opposition at docket number 249. So it's funny. I love how it's like Russell eventually quit spurging out. I told Matthew Hardin, that's fucking hilarious that he did that. But this opposition addresses one of the material false statements. And it's the accusation that Matthew Hardin had violated the court's protective order. Even though Russell confesses he had not read the order, and even though the undersigned counsel repeatedly asked him what provision had been violated. And yes, Russell Greer has complained 3 separate times that they had violated the SPO, but they never identified the nature of the violation. And the best part of this is, and I just love how he writes this. And even as he raised one lone point in his opposition, Greer effectively argues why sanctions are necessary, rather than demonstrating why they're not. Greer confesses to what the defendants have argued all along. He assumed what the protective order was without bothering to read it. And remember, chat, he kept on crying that his brother and his dad's information was being released in the emails that were being attached as exhibits. And when it came time for the protection order, the court said, well, I need a copy of it. I need a copy of it. And the court said, you could download it here. And Russell goes, oh, okay. Well, I guess it's not a violation. So that's the problem here. And no matter that 2 separate judges have now informed the undersigned the counsel didn't violate that order, not only did the magistrate judge and then the district court judge like, you haven't violated it. You've been a good boy, Matthew. He repeats the allegation again. And that's the thing, guys. When the court says it doesn't, you keep sticking on that. You start making false statements at that point. It's one thing to make the accusation and the court says that didn't happen. I ruled that actually didn't happen. They acted in good faith. Okay, well, if you go again to say now again they acted in bad faith, the exact same thing, you are now making a false statement because the court has ruled otherwise. And it says Russell repeats the allegation, stating because the undersigned counsel violated the order, as Mr. Greer imagined that order should be, rather than it was written, defense counsel must be sanctioned. Yes, remember, guys, that was Russell's thought was, if you don't, it's just privilege, don't share it. He didn't do the thing of for attorney's eyes only or following pursuant to the protection order. He didn't do any of that. He just didn't like it. The second false statement was his eager witness named Steve Taylor. Guys, remember, Steve Taylor was the guy who had cancer and died, and Russell never knew about it. That's a problem. That's a problem. Russell never knew he's dead. He's the guy they had a falling out with. But yes, Russell has submitted obituaries showing that he died months earlier. But the only reason why Russell learned about it is because the farms went and looked around and found it. It's the only reason why we know this guy's dead. And yes, Russell's behavior will not be countenanced. So they talk about the Rule 11 sanctions. They're meant to serve purposes. You deter future abuse, punish present abuse, compensate victims of litigation abuse, and streamline the court dockets. And so to impose Rule 11 sanctions, you must first find that a pleading or written motion violates Rule 11. And to avoid sanctions, a litigant's conduct must be objectively reasonable. And that standard applies whether you're an attorney, pro se litigant, or both. And the legal contentions are frivolous when the party advancing them has not made reasonable inquiry into the governing law or the relevant facts. And here we have that. Russell never checked to make sure this guy he talked to years ago is still alive, still around, or anything like that. It's been a long time. And the standard is objective. So it's not based on, well, I thought I worked hard or I did a hard enough research. No. It's objectively, did you do enough work on this? And Russell clearly didn't. Russell clearly didn't. Good faith beliefs are not good enough. Russell freely admits that he did not make a reasonable inquiry into the governing law. And Russell only asked for a copy of the order after repeatedly accusing undersigned counsel of violating the order. He doesn't even attempt to deny he accused the violations of the order he read. Instead, he confesses that he assumed there was a blanket special protection order. He states he was just going off a blanket assumption. Unfortunately, he's got a little blankie. So unfortunately, he was deeply wrong, and unfortunately for the defendants, their counsel was forced to repeatedly point Mr. Greer to the relevant order and seek clarification as to what he's being accused of. Even as Greer gave notice that he would seek revocation of undersigned counsel's pro hoc vice status. Yet to this day, Greer has failed to withdraw his scurrilous accusations against counsel. Once again, Matthew Harden breaking out the $10 words here, chat. The $10 words. Those are the good words. Bella's saying Ori knew he's dead and already had the obituary. No. Hell no. You are giving Russell too much credit. He is not that competent. He's not that competent. So, Greer claims he was ignorant of the requirements, but that's legally irrelevant because his assumptions were objectively unreasonable. There's no room for a pure heart and empty head defense. And that's true. Your Honor, I'm just a Todd. No, at some point, it does not work. And this is an example of that. You can't have a pure heart and an empty head. The point that he keeps on doing this for orders that exist not on paper but only in his mind amplify the need for sanctions because, listen, Tardo, it's not what you think is happening. They need to do they need a black woman to come in and clap for Russell, stop making things up. Read the rules. They need to do that for him. Because it's just not working. There's too much drool probably sliding around inside his skull. He needs a shunt or something, I bet. Now, also the threat of retaliatory sanctions illustrate that sanctions are a game to him rather than an issue to properly address his own conduct in line. But the issue that he failed to address, the eager witness, but deceased witness, is also emblematic of this. He feels he's simply free to file documents with the court as a result of pique and without conducting even the most basic or cursory research or investigation, prefer burning his legal opponents. Indeed, his behavior is why this litigation has spanned almost 5 years and has now been assigned not less than 3 separate district court case numbers. The defendants are prejudiced to an extreme degree when he endlessly changes his narrative about who will testify, or when Greer endlessly accuses the undersigned counsel of unethical behavior. And they say, although not a subject in the instant motion, Greer's accusations towards counsel have had the effect of tampering with the witnesses. It's when he told his brother that Matthew Hardin is a very unethical person. Yes, it is witness tampering. And they say because he has not addressed the issue, it should be waived. And failure to raise issues constitutes waiver, and that is throughout the country. Federal court, state court, everywhere. So in the event it were generally to construe the earlier filings related to Steve Taylor as a response, we're going to address those motions, saying even if you try the other things, we're going to address it anyway. Because remember, Hardin is right. The court will probably give him a retarded benefit of the doubt, so they should address the issues. In that filing, he had a falling out with Steve Taylor. And he says the falling out occurred later that year, which is back in the day, in 2021. So it said Mr. Taylor died on January 17, 2024. The problem is a simple one. On May 2024, Russell told the district court that Mr. Taylor was eager to testify, but could only do so if this case was retransferred to Utah. By that point, Mr. Greer and Taylor had not spoken for approximately 3 years, and Taylor had been dead for over 4 months. And as Greer tells that he had no contact from 2021 to 2024, and had no idea he died until later. Yet, even though he had not spoken to him, Greer filed a pleading indicating that not only was he eager, but also he could do so if the case were sent to Utah. And this is the thing here, guys. This is the thing. He's failed to do the most basic investigations and due diligence. You have to. You have to. He didn't try to reach out to Taylor to ascertain things. Nor did Russell inquire whether or not traveling to Florida would be convenient or inconvenient. And if he had done a basic research, he might have found out that he was dead. And that would have undermined one of the core grounds that he sought judicial relief. But Russell didn't bother to do a basic investigation. He simply projected his own desires for retransfer onto the deceased Mr. Taylor and used Mr. Taylor as a little more in a stage prop in support of his litigation goals. Oh, this is brutal. Having obtained the result that he wanted, Steve Taylor became suddenly unimportant. And Russell thereafter failed to disclose him as a witness, agreeing that only Scott, his dad, and his brother Nathan were going to be witnesses. To this day, he's never withdrawn the representations. And not only has he made a mockery of the justice system by using the deceased, okay, he does it every fucking day. Every fucking day he does it. Every day Russell makes a mockery of the system. I mean, that's just the thing here, Chet. That's just the thing. Oh, that's just the thing here. That's the thing here. So, Mr. Greer, he even attempted to blame the defendants for bringing up Mr. Taylor in this case as part of their own efforts to investigate the claims. When he stated to the guy, hey, I have a vital witness. And he's like, how dare you look him up? And it says it's insulting that the defendants are now dragging up the memory of a dead friend of Greer. Which is funny because it's like the goose meme. Who told us about him, Russell? Who told us about him? So there you go, chat. That's where we're going to things here. Now, from there, Matthew Hardin started doing some good stuff. This is the thing that I think I was waiting for to see happen. And I think this is starting to become the beginning of the end for Russell. And it is a motion to seek a revocation of his informa pauperis. Which, what does that mean? Well, they're looking to remove Russell's informa pauperis, this IFP status, which means he's allowed to proceed without having to post, for example, the amount necessary to file a lawsuit, which is about $400. He's allowed to proceed freely because he's a pauper, meaning Russell's admitting he's not only retarded, but he's also broke. And this is the thing that Russell Greer and Acer Thorne do. They abuse the system by getting this advantage. And what they do with it, they're allowed to then just file willy-nilly. Because for people like Russell Greer and Acer Thorne, $400 a pop, they wouldn't do this all the time. But in America, we do like the idea and support the idea that if you are an indigent person, you should not be barred from being able to seek redress in the courts. Sadly, this gets abused, but it has to happen at some point. And it's a thing that I'm glad we have in America. Yes, Little Miss is correct. This is like the civil version of being indigent in a criminal case. It is. It is. It is. So this is the defendant's motion to review for the, and it's called IFP. When you see Informa Pauperis, you'll hear it IFP status. So they are now moving for the court to review the Informa Pauperis status based on representations made in the latest filings that Russell's done. So Greer asserted that he could pay the full judgment. Presumably, Greer either means that he has the ability to pay $1,000 or the president ability to pay $774. The filing fee for this court is $405, but it was $402 when the case began in 2020. Regardless of what figure Russell has in mind, it appears Russell's no longer indigent. And then the 10th Circuit has explained that a change in financial conditions during the pendency of litigation warrants a review. And it's correct. So if Russell won the lottery tomorrow, there would be a change to that, and there should be a change. And they point out leave to proceed without prepayment of fees and costs is a privilege, not a right. The courts have discretion to revoke that privilege when it no longer serves its goals. When the financial condition improves during the course of litigation, the court may require him to pay fees and costs. So they point out that they upheld in the 10th Circuit, there was a revocation when a guy who had a $1,300 monthly income through Social Security and $1,200 of monthly obligations. So that means he had quite a bit of money left. He had a little bit of money left over. He had a $105 monthly fund surplus. So the 10th Circuit explained the plaintiff had some discretionary money to pay filing fees and that she could pay the filing fees. And also, like in Lewis, we're concerned that Russell was an abusive litigant. That's part of the issue. You're now catching the court's eye. And if you want to be an asshole, they're going to do this. And they point out Russell's tactics have become more abusive and already led to an award of discovery sanctions. With more motions pending for more discovery violations and false statements, it's just adding up. It's adding up. And at the risk of beating a dead horse, the defendants also point out this case involves a copyright to a book that literally details Russell Greer's pattern of vexatious litigation nationwide. And it says, similarly, the 10th Circuit has held an individual who at some point during this has the ability to pay fees, should be required to pay those fees rather than continuing to go IFP. So they keep pointing this out. They keep pointing this out. They keep pointing it out. There's things there that they can do this. You know, if you get your tugboat and then you have refunds of student loans or your tax refunds, renders you no longer a pauper. Once again, it's about how big of a dickhead you're being. If you're being a pretty reasonable party, it's probably not going to be an issue. But if you start fucking around, the courts will start fucking with you. They also point out the IFP was granted 5 years ago. And it's natural that things might change over the course of 5 years. And the recent motions make it clear that he has the full capacity to pay $775. And it says, although Russell might prefer not to do so. That's also a valid argument. It's been 5 years. We need to reevaluate. It says this court should therefore investigate Russell Greer's financial status and revoke his IFP if appropriate. So they want it to get screened and they want him to be examined. Just like Acer Thorn. And Acer Thorn, there's the court went through it. The court went through it. And we're now getting to that point for Russell where things are starting to pile up. And a little later down the road, Matthew Hardin the next day filed some information with the court that shows Russell is not entitled to this. And where do we see these things here? Well, we get to Russell's IFP things here. So we're asking the court to take a look at it again. And they're bringing up things that are going on. Now, there are times where the IFP screening can result in a mandatory dismissal. And they bring this up. It may result in a mandatory dismissal for several reasons. Only one of which is the failure to state a claim, because this court need not accept it as a given the allegations are true. The review is not coextensive with that under Rule 12b-6. So they have recognized a case can be dismissed when an IFP plaintiff cannot corroborate any of the facts he alleges. And that's part of this, chat. So not only when you file IFP, the court will stop, and the court's supposed to stop and read your complaint and go, I have to give you this waiver, but are you also jerking us around? And that's a thing they have to consider here. So they talk about this, and this is where we're starting to get to and I love this, we're getting to the meta-ness of this, where the Southern District of West Virginia recently recognized that it's proper to deny IFP when it appears the plaintiff is bringing the instant action for an improper purpose. And this is Acer Thorn's David Stebbins versus Josh Moon et al. And we're getting to where this law is starting to build up. It's starting to get together, and it's just getting fucking ridiculous. But now, as I thought before, Acer Thorn and Russell Greer might be looking at the other filings and working off of each other. Matthew Hardin's now able to use case law from these lolcows. And yes, we now have lolcow law. There's case precedent you can use. Oh. And he points out this is especially so when the plaintiff appears to bring copyright claims against defendants based upon their criticism of them online, which is not a proper use of copyright law. And that is also that's what Acer Thorn does. You criticize him, he copyright claims you. And the courts have a clear obligation to exercise screening authority to protect litigants from harassing, abusive, and meritless litigation. Because if you get IFP, you're basically playing for free. You're gambling with house money, which isn't fair to everybody else. They also point out it was 5 years ago, so you need to take a look again. But it's unclear whether the complaint was ever screened before the magistrate judge approved the application. And they put out the amended complaint supersede the original complaint and renders the original complaint of no legal effect. And that's true. So they're arguing, Judge, you should reevaluate the claim and reevaluate the determinations because this is a brand new complaint. The old complaint no longer exists. And that's how this works. When you file a new complaint, the other one is no longer legally relevant. So, therefore, the operative complaint should be rescreened to determine whether it's frivolous or improper. They also want the court to consider all evidence before it could and should pierce the veil of factual allegations rather than assuming they're true. They will point out that there's an accumulation of evidence Russell Greer is using this for an improper purpose. As evidenced by his numerous demands for a settlement that does not remove any copyrighted work or recompense him, but instead stifles the defendant and all others who seek to discuss what Russell Greer, a public figure and author of a book, relating to vexatious litigation. And remember, guys, that's all Russell wants. And I said that before. He doesn't want money. He just wants the farms not to talk about him. because apparently hookers will suck his dick and Taylor Swift will pay for his songs if the Farms pages don't exist anymore. That's literally what is going on here. So they point out that Russell was already denied the protection order that he claimed he had because it was just Knoll's criticism raised First Amendment issues. And Russell Greer demands that they remove all mention of his name from the internet. He does explain, going back to 157, that he feels mocked for his facial paralysis because why this case was filed. What? You mean like this? What? You mean like this? Is this what you're talking about, motherfucker? Did your facial analysis? Am I talking about? I know you're not that retarded when you speak, but it kind of get that way. I kind of feel like that. But yes, case filed because of his facial paralysis. Well, there you go. So they talk about he's reiterated that he's offered twice to settle if his name, not only his copyrights, are entirely removed. And that's true. He just wants it removed. And the thing where if you type his name in the farm, like the computer, like the server deletes it automatically. And it's like, no, we're not fucking doing that. Why would we fucking do that? Why would we fucking do that? Now, from here, they do attach a couple of exhibits. And this is, first of all, this is the actual stalking injunction. You know, because Russell Greer did try to get his stalker children stopped by the court. The court said, we're not going to grant your request. Why? It's not clear whether we have jurisdiction because not everybody here, and it appears not to have occurred here. There's some First Amendment issues or procedural issues. There's issues about giving the respondent notice. And it says, some of the events appear and do not appear to have been undertaken by Knoll, but rather by third parties over whom the respondent may not have control. And to the extent, it's not clear whether he directed this. So therefore, your civil stalking injunction will not be filed. Oh no, Russell. Oh no. Oh no, Russell Greer. And then for Acerthorn, there is a thing here, guys. We're gonna do the Acerthorn stuff at some point, I promise. At some point we will. But this is Acerthorn getting BTFO'd by the magistrate for his IFP case. So there is some information there. It is a hilarious read because the magistrate in that case, the West Virginia court, is not fucking around with is not fucking around with Acerthorn at all. Is not suffering his retarded ass. So I will say they're doing it the right way. They're doing it the right way. They're doing it the right way. So, moving on from here, chat, because Russell did file his amended complaint, and there were some issues about responding to what was going on. There was a motion for extension of time filed by Matthew Harden. He's like, we need time to work on this. And he's like, I need till April 14th. Please give me till the 14th. The court has granted him till April 14th to respond. So, not really a super big deal there, but I just wanted to give you guys an idea of what's going on here. Now, this next one here is kind of a dub for Russell. And I think even though the court did this, I think it's a reasonable ruling. This is regarding Russell's discovery issues and the motions to compel. And like I said, we're going to go through this, and I don't think it's improper. I don't think it's improper. So it's a memorandum of decision order. So this case was referred to the magistrate judge. And before the court is the issues about the motions to compel Russell Greer to comply with the request for production. So they conclude that it's not, oral argument's not necessary, and they're going to deny the motion. Well, why are they going to do this? Well, Here's the issue. They requested that Russell Greer, in the discovery regarding the loss or deletion of any records, they want any and all written electronic documents which reflect or memorialize the loss or deletion of any record at issue in the case, or which is relevant in the case, or which anyway relates to the factual or legal claims at issue, including but not limited to emails, pleadings, items requested in the first request for documents, correspondence, and all other material, along with any documents which reflect your efforts to recover such deleted or lost records, or your efforts to ensure such documents were not lost or deleted and were preserved from July 2020 till today. So the argument that the court is understanding it as, Russell must produce this information because he has not timely raised any objections, but because he has made previous assertions that he has lost or destroyed numerous records. And Russell says that he objected to the relevancy first, and specifically asserted that information about any other cases was that he may be involved in is irrelevant. And additionally said that, Russell says, these guys are engaged in a fishing expedition by requesting any and all deleted or lost records without specifying which emails, pleadings, and things, and the items have supposedly been deleted. Russell further contends that producing information about other litigation he may be involved in would be burdensome, and the defendants can access this information through public databases. And even after searching his records, Russell did produce a summary of his litigation history and produced documents related to past lawsuits that he could find. In his email, Russell said he didn't have every document more than the originals. He says, I don't keep files that old because I don't have lots of space. I lost both my laptops and I cannot search, so I cannot search them. So what happens here? Because they're claiming that the court determines the request constitutes impermissible discovery about discovery. And this is an actual thing, guys. This is an actual thing. You do kind of push the limits when you're asking about, well, we need proof you did the things we're asking you about. Requesting information regarding the process by which Russell's preserved the documents. Discovery is limited to information that is relevant to a claim or defense and proportional to the needs of the case. Discovery regarding discovery retention purposes generally does not meet those standards. Courts have held that discovery into the process by which a party searches, reviews, or collects documents is not appropriate unless it's directly relevant to the underlying claims or defenses. And not only are the responding parties best situated to evaluate the procedures and methodologies they use to search for that information, but such requests for meta-discovery also threaten to extend the already costly and time-consuming discovery process away by swerving away from the actual issues of litigation. Now, for Russell, this isn't really a time-consuming and monetary issue, but for example, if there's discovery and you're involving Chase Bank and they're going through tapes, data tapes, and all the things that are out there, providing updates in the documentation on the process of recovering everything is not permitted unless it's something that has to go on here. So they say the discovery on discovery requires a factual basis to draw into question the compliance, not mere speculation. So the court denies the request for 3 reasons. First, they failed to demonstrate the factual basis for this. They allege that Russell's destroyed all kinds of records, but despite that statement that he conducted a search and explained this, he doesn't have things. Discovery compliance does not require a party to certify production perfection. It requires a reasonable search. And it says Russell's tried that. And you know what? The courts, if any other party said this, what Russell said, this would be acceptable. This would be acceptable. It says second, the sweeping demands and notice, this is the court now doing this, sweeping demand for discovery and preservation practices relating to any and all documents is kind of that is a bit much. And the court will not permit wasted time wading into collateral discovery, especially when the issues in this case have been significantly narrowed. It's copyright now. which it makes sense. I understand what Hardin was doing, but I also understand why the court's doing this. And third, the sheer overbreadth of this request goes to the lack of proportionality. And fails to account for the fact that a lot of the prior lawsuits are accessible just as much. It's all public documents. And the request for extensive documentation led to the loss or deletion of any and all records, with no identification of the documents in question, makes the request impossible for Greer to respond to. And I think that's a fair argument. Well, what am I supposed to give you? Any and all? Well, what's any and all? Like everything? Because not everything's relevant. And even if the court points out, even if it were more specific, we're not going to grant it. We're not going to grant it. It serves no meaningful purpose. Russell Greer has already provided a summary of his litigation history and the documents he can recover. And yes, defendants have access to public court databases where the past lawsuits are available, further diminishing the necessity of delving into the discovery. They say, indeed, whether he objected or not, the federal rules of discovery, and Rule 26 is discovery, allows a court on its own, sua sponte, to limit the frequency or extent of discovery if it determines the discovery sought can be obtained from other sources that are more convenient, less burdensome, or less expensive. And defendants can access court dockets as easily as Russell. They can obtain discovery without first obtaining discovery about discovery. I still think it was worth it. I still think it was valid. Notice the court is not saying that Matthew Hardin's acted in bad faith, but they're just because this is a normal discovery issue. So Russell, you're not going to be able to sanction this conduct. But I do understand the magistrate saying I'm not allowing it. But yes, chat, Matthew Hardin and Joshua Cotter Mood got racketed. Sadly. But it makes sense. It does make sense. I don't think this is an improper ruling. I think it's actually a good ruling. You know, the court's being consistent and the court is doing what it would do in any other situation. So it does happen. It does happen, chat. As things went on, because we got to the end of the month, and notice, chat, we're now up to the end of March. Time traveled. Like, there were some things happen, but there were some lulls in the action. Lulls, not lulls. Lulls. There were some lulls in the action. And there was supplemental authority regarding the IFP status. And this gets good, chat. We get some good information here. So they bring up things. They talk about the attached, this is a police report, obtained from the Nye County Sheriff's Office in Nevada on November 22nd, 2024, that Russell had significant financial resources, which he appears to not have disclosed to the court. Specifically, Russell told the Nye County Sheriff, and this is what Russell said, and we're going to get to this if you don't know the story. I run an LLC in Nevada that wanted to purchase the Cherry Patch. The Cherry Patch is a famous whorehouse. The rustic building with the female statue in Crystal, Nevada. I had actually written the owner directly and her representatives for a year trying to convince her to sell. So Russell is trying to buy the brothels, chat. He tries to buy these brothels. He tried to buy the Hoff Bunny Ranch before it got demolished. And there's actually video on the farms of Russell going there to the ruins, like he's at the fucking ruins of the Führer bunker. And he's crying about, look what they've taken from us. By God, we will have our home again. It is very funny. And they talk about Russell thus appears to have told law enforcement this for 2023 to 24. The plaintiff was attempting on behalf of an LLC he runs to purchase a piece of real estate and property in a statue in Nevada. He points out that the sale was listed for $1.2 million. And the infamous brothel was on the market for this and with old mattresses and all the shit in it. But this is true. This is a problem. If Russell Greer has access and the wherewithal to purchase a property for $1 million, this court should deny his IFP status. And then he has a controlling interest in a Nevada LLC. How does he have that? How does he have all this stuff, chat? So what exactly is this here? Well, they do cite this. This is the police report. This is the police report. He's alleging fraud because he claimed he was going to be able to buy it. And the people who wanted to destroy it, a bunch of incel prudes. And that's the thing. I kind of wonder if Nick and Russell could be friends now because they both like hookers and they both like, I'm assuming gay sex. Do you think that they're friends now? Do you think they're like fellow travelers? They probably are. Right? It's interesting in hindsight how they probably would be broskies nowadays. So this is a call in. This is a call detail report. Imagine having to take this. Imagine having to take this fucking police report. So this is from November of 2024. This is absolutely fucking awful. Contact Russell Greer. So, the reporting party is currently inside the county. I've already spoken with the deputy. They refer to me complete on report. So what do we actually have here? What's going on? So all this is kind of just all the stuff here we don't matter with. He's reporting a criminal offense that occurred within Nye County, Nevada. So what is he arguing about? Okay, so what happened here? It's a formal brothel. Please, it's about a formal brothel. Are there witnesses? Yes. So, he talked about witnesses. Well, the news media was there. And he says, I can provide personal information about this. And it says, I'm seeking the police report against Jan Jensen and would ask for charges to be brought against her under the Nevada statutes, obtaining money, property, or labor under false pretenses. So what do? They bought the whorehouse and they promised, we're not going to destroy it. Then they destroyed it. Based. Mega based. Suffer, Russell, suffer. Yes, she is the owner of 2 brothels she just had demolished in the Crystal, Nevada area. And this is one of the places where you had these brothels that were out in the middle of fucking nowhere. That's the only place you could do these things. Like the Bunny Ranch and all these other fucking creepy places were not done like in Las Vegas. You had to go out in the desert to unincorporated areas and unincorporated towns and set these up. So it says Jan deceived the previous owners and hid the fact she is strictly against prostitution. Dennis Hoff previously owned the properties, and there's no way he would have let them be bulldozed. Yes, that's probably true. But he did! He did, Nibba. Even for a $1 million purchase. When Dennis died in 2018, he let the property shift to his successor, Suzette. She sold the brothels in 2022, and I don't believe she knew of Jan's hatred towards sex work. The funny thing is, I would really like to get Russell and Alyssa Mercanti need to have a collision course as well. Russell would be like, my night sex work. Well, can I sex work you? I wonder how that would go. She'd be like, ew. But it'd be so worth seeing it happen. We just need all of this to collide, chat. We need all of it to collide. Alpha Fox says, does he have standing to do anything and then file a report? No. There's no standing here. There's no standing at all. That's the best part. So, therefore, Jan purchased the property under false pretenses. And she outbid Russell. Under the statute, false pretenses are a misrepresentation of some fact or circumstance which is not true and is calculated to mislead. May be consistent with any words or actions intended to deceive. Now, there's no way Russell talked about this. He actually handed this to somebody because there's no way he could fucking read all of this off. And the person typing it out could understand. Well, they could understand this, Therefore, Jan Brendan the property on false pretenses. I'm a statute, false pretenses, or misrepresentation. And some fact or circumstance. And at some point, that person's sitting there taking, information down on a computer terminal somewhere is just looking at their fucking revolver and being like, maybe today, good friend, maybe today. You know, they're just looking right at it. Like, maybe that looks tasty enough. Then it says, I am directly harmed by Jan's fraudulent purchase of the property and subsequent bulldozing. Because I run an LLC that wanted to purchase the cherry patch, the rustic building with the female statue and crystal. I have actually written to Jan directly and her representatives for a year trying to convince her to sell. These were historic buildings that nobody can ever operate because some crazy woman lied to obtain them for the sole purpose of demolishing them. Suffer, Russell. Suffer. 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 He says, I believe under the penalty of perjury that Jan lied to obtain the property. A trial would have to be held to get all the facts, but prima facie, a crime is indeed committed. The facts are clear. She lied to obtain the property. I have legal standing to file this report. I am harmed as a person who wanted to run the brothel, and I am requesting a report to be filed so the county attorney can press charges. I lost my opportunity to test out the hookers. So there you go, chat. There you go. I feel bad for these people. You know, Officer Finlayson got my heart. Oh, I have 07's in the chat. He took that report, and number one, he didn't need a pistol. He didn't need his pistol. And number two, he didn't pistol whip the shit out of Russell. I mean, he looked at his pistol, he decocked it, and said, not today, old friend. Not today. So give this officer, I'm normally not one, you know, we love our cops. You know, they're so important. We love our troops and our law enforcement. But really, we should. You know, they didn't kill Russell either. So, you know, John Cena style. That's right, chat. That's right. Oh, that's so, you know, you got to take the wins where you get them. You got to take the wins where you get them. Now, that rhyme was better than Baked Alaska, because I know, but I forget how Baked Alaska did it. So, oh, could Russell just buy some land and open his own whorehouse? Yes, but he's trying to, like, I think he's kind of like, you know, when you meet the Robinsons, when they go to, like, when you go to, like, you get to the end of the story and it gets really heartwarming where the kid gets adopted and they go to the burned out, like, vacant observatory. And, you know, I think Russell kind of saw it where it's like, you know, Rob Thomas is playing in the background and he's going to, like, montage it into, like, the thing it needs to be. Like, I think that's Russell how thought that would go. But no, it did not work for him. Sorry, Russell. Yeah, and there aren't many places in Nevada that will let you open up a new brothel. And the only other way you could do it is even if you can get it, you might be forced to basically be out in the middle of the fucking desert, away from everybody in an unincorporated area. So, like, these places like Crystal, Nevada, they ended up, like, they couldn't stop it initially, and they were there, and people wanted the shit gone. Like, the people in those towns are happy that shit's gone. So, yeah, you'd have to bribe a lot of people. Probably. Or threaten to bury him in the fucking desert. Brothels are close and always have been, yeah. There are only 2 counties. Yes, the thing is, though, in Nevada, guys, if you don't understand, a county in Nevada is fucking huge compared to everywhere else. There's only like 10 counties in the state of Nevada. It's the same thing like Arizona, guys. Out west, the counties are like blah, in size. So maybe he was conceived there. Aww. Where you made no clear from a man. The weird old baby muscle drew from his head. Oh, yes, the counties are my sized. Patrick Cake says, we love our hookers. They're so important. We love our whores and the pimps who enforce them. All right, moving on. So on April Fool's Day, very fitting, Russell filed a very serious motion. Russell filed a very serious motion on April Fool's Day. This was, Russell's like, I'm serious about this. I'm being serious. No, Russell's just like, I'm super serious. It's like Wonder Pets. We are seriously serious. So here we go, chat. Russell filed a motion for sanctions against Matthew D. Harden. Not just against the defendants, but against him. Oh. This is where Matthew called me. He's just like, I don't know what to do. And I'm like, you have to look at it. It's like Lieutenant Spears and Band of Brothers. The best thing you can do is convince yourself you're already dead and fight like hell to make it out. That's what I think happened to Matt. I think that really got through to Mr. Harden because he's a strong man. So once again, chat, remember April Fool's Day. For the past year, by and through their attorney, the defendants have filed countless unnecessary notices and motions. On March 31st, the defendants filed a notice of a police report the plaintiff made in 2024. Not only did they contort what the report and what plaintiff said in the report, they literally posted the entire report, Russell. There's no contorting. But by filing that notice, they are causing unnecessary delay in violation of Rule 11. Now, remember, guys, when it comes to Rule 11, you have to provide a safe harbor for the opposing party to withdraw. And remember, Matthew Harden gave Russell 21 days to withdraw things before he filed the motion on February 20th. You have to give them a chance to withdraw and correct the action. This isn't new. The defendants have plagued this case with abusive and annoying notices ever since Matthew Harden, who's not even licensed to practice law in Utah. By the way, chat, Matthew Harden and I were looking at it. I could, even though I'm not licensed in federal court, in Utah, I could just fucking pro hoc in, too. That's funny. Like, Utah just lets you in as long as you're licensed somewhere. Like, I could pro hoc my shit in this way. So, that's the funny part. Bella says I'm a little low. Hold on here. Let me see. Hold on, let me mix some stuff up here. Edit audio settings. All right, here. We'll crank it up a couple decibels. There we go, chat. There we go. Am I better now? So, you are fine. Hell, well, do you want to live in Utah? No, but I could pro hoc into Utah at this point. And as a guest in this district under a pro hoc admission, enjoying the case. You don't even live there, Russell. You're a guest too. The only way these abusive notices will stop is if the defendant's counsel starts getting sanctioned. So it goes to the thing we just went to, chat. By and through their attorney, they filed a notice purporting to support their motion to withdraw the IAP status. The notice alerted a police report to what Russell filed. The report was against a woman who bought land Greer had been trying to secure through investors. This woman bought the land through false pretenses and had the land purposely demolished and put on a show for the demolition because she disagreed with the historic property subject matter of it being a whorehouse. That's wrong. That's theft under false pretenses. It's wrong. But most of all, it's nothing to do with this case. Oh, you're the king of what has nothing to do with this case, Russell. Russell's be like, I should know. I file all kinds of retarded shit. I'm a subject matter expert. The report has zero to do with this case. Channeling is Vince McMahon. No, this is frivolous. Oh. The defendants are trying to reply that I run an LLC in Nevada that wanted to purchase the cherry patch. That therefore somehow Russell has access to millions of dollars. Well, yes, if the property was bought for millions of dollars and you're trying to buy it, are you saying that you're just randomly asking people for property and you don't have money? I mean, we know that's true. But, like, what the fuck, dude? Come on. There's a few things wrong with this notice. The defendants are confusing the properties. There was the love. I love how he does this. He's like, listen, you fucking casuals. There's a difference in your whorehouseology. I know all kinds of whorehouse shit. Do you? No. So let me school you, you casuals. Yes, we have the Love Ranch South. And it was formerly located at 3850 South Appaloosa Lane. Then there was the Cherry Patch Ranch, which sat at 3374 South Appaloosa Lane. Up the street from the Love Ranch South. It was described in the report as the rustic building with the female statue. The Love Ranch was $1.2 million. The Cherry Ranch was considerably less because it had not been maintained. This is a great fucking argument here, Russell. It wasn't $1.2 million, but it was like $100,000. Oh, so he's like, I didn't have access to $1 million, but I had access to 50. Fucking bravo. Bravo, Russell. Bravo, Russell. You fucking played yourself. If the defendants read the report, it clearly said plaintiff through investors in the LLC wanted to purchase the Cherry Patch. So at the most, through investors, he had access to 50 to 100 G's. The Love Ranch was a nicer $1.2 million property. Plaintiff would love to have also managed had he had access to that money, which is undetermined if people he knows could have paid that much in cash. The defendants are also confusing the $1.2 million amount. These plebes, these Scandinavian incel prudes, they don't understand whorehouseology like I do. The amount was publicized through the news when the LRS, the Cherry Patch, and hundreds and 100 acres of other land were all sold together in a combined sale. So it's doubtful Love Ranch South was by itself $1.2 million. At no time in the report did plaintiff purport to be personally wealthy. He simply said his LLC wanted to purchase it, but gave no details how he saw it to. Not only the defendants twisting that report said, that has zero to do with the case. And they are causing unnecessary delay with this litigation by overburdening the court with matters that have zero to do with the case. The defendants also filed number 268, claiming to reaffirm his access to millions of dollars. This is false. Well, you're a tard, man. Plaintiff has established that he never claimed to be wealthy. The purchase was going to be through investors, and the said purchase is not worth millions of dollars. Okay, well, you're establishing that now. That's clearly wasn't the case here. So Civil Rule 11 says the parties agree to engage in anything, filing hasn't been used for any improper purpose, such as to harass, delay, or needlessly increase the cost of litigation. Well, you have no increased cost of litigation, Russell. So, and yes, this is in a long line of frivolous notices from the defendants. If the court kind of looks through the docket, it will see the defendants have plagued this case with numerous frivolous notices. A notice regarding return payments, which have nothing to do with the merits of the case. Well, it shows you're being a shithead. Motion seeking to review IFP status, which would cause a delay. A motion that sought to have Greer disclose irrelevant information regarding irrelevant information in Greer's personal life. The defendant's lawyer sent Greer a threat through the email he was going to seek attorney's fees if he was granted the short form discovery. And Russell gets to say, that motion was denied. No one denied. Yes, Russell. You got your one dub, Russell. Congrats. You got your one dub this year. In 2024, there were multiple notices complaining about dates on documents. Yes, if you're not fucking doing it right, yes, they're allowed to complain. We are allowed to complain. You're allowed to complain about profane language in private emails. There are notices that have no purpose being filed in court. as they do not help with the defense. No, but they are allowed to show the court you're being an asshole. They are allowed to show you're being an asshole. They say in total there have been over 30 notices and motions filed. Okay. Notice, we're at Russell. Because of you, we're on filing 269. Docket entry 269, brother. Yeah. And they say to prevent these notices to continue to plague the docket, they want they seek fees and a written admonition against Matthew Hardin. A written admonition versus a verbal admonition. That says, although the rule allows attorney's fees to the opposing parties, it's one of but several methods achieving the goals of Rule 11. Sanctions can be made all together, and it says, no reasonable attorney would keep filing as many unnecessary notices as Hardin has. I fucking would. I'd be filing this shit all the goddamn time. I think Hardin has been doing a great job of informing the court of all the shit you're doing wrong. The plaintiff seeks a reasonable fee of $5,000 against Hardin because it is a small but reasonable deterrent to get Hardin to cease frivolous notices that cause so much delay. Notice that because Hardin asked for $5,000, Russell's like, I want $5,000, no. Because now he's seen that value, Russell's now latched onto it. And I don't know if Russell understands he doesn't get the money. He doesn't get the money. It doesn't go to him. So anyways, the plaintiff also seeks a written admonition. Yeah. And then signed by Russell Greer, my left foot. Well, there you go. There you go, chat. There you go. Sean just realized it's Saturday. Did I? No, but I mean, it does suck it's Saturday already. So. Yes. So, and that's the interesting other thing too. Yes. Now he's saying $5,000 is a small amount. Well, apparently it was fucking crippling for you, Russell. And so there were some updates. The court did produce some entries in the system here. The court actually, so there is there was something the court set, and this is going to be a big deal for you guys if you guys haven't seen this yet. We're kind of bouncing around here, but I'm covering some of the things that were set. So this was a setting for. This is a setting that on May 6th, there will be a hearing. It's going to be on Zoom. I don't know if we're going to be allowed to be there or not, but don't show up as Salty Dick Nuggets 1488 or Reinhard Heydrich was right or your boy Heinrich or, whatever it is you're going to show up as. Don't show up as that stuff. Don't show up as like Kike Slayer Esquire or all the other things. Don't do what people did during Nick's arraignment or at April's fucking pretrial. Don't be these guys if you can get in there, chat. Yes. Don't be Mr. Hibbler 6969. Don't do this, guys. Don't do it. If you guys get in there, don't fuck it up. Yes, Harry Sachs 1488. Don't do it. Anyways, there's going to be a big Zoom hearing, which is going to determine a lot of motions. There's a hearing on attorney's fees. There's a motion for sanctions, the orders on short form discovery, the orders on motions to expedite, the motions to stay in memorandum of support, the motion for the bonded stay from Russell, the review of the IFP status and the memorandums for that. All of this is getting heard on May 6th. Now, that tells me a lot of things. The court is getting really fucking tired of the case. And I do think the court is going to start fucking crushing Russell. I assume this is going to be a pretty big L for Russell that day. I'm willing to say that because I think we're getting to the point where the court's just going to start I got a bunch of motions here all at once. Bam, 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 denied. I think that's what's going to happen. I'm expecting that to happen. So it'll be May 6, 2025 at 1 p.m. Via Zoom. So we'll see what happens from there. J-Rock says, how about being Sean Martin Esquire out of Ohio? Can I use that? Funny thing is, Chad, if you Google me in the Supreme Court of Ohio's website, there are 2 Sean Martins. that are attorneys, and we both have our names spelled the same way. So if you try that, you might fuck over another guy. So don't do that. Don't do that. Don't do that. So, yeah. It's your boy. It's your boy, RH. You know, don't show up as Ernst Kaltenbrunner appreciator. But yes, I think we're getting to the point, chat, of we're getting where Russell's going to start suffering setbacks in a really fast order here. So that'll be a thing. The guy caught strays. Yes, he has. Some people have, well, like I get things, people send things. Like I got a bunch of like probate documents, and I'm like, uh-oh. And I called them. I'm like, hey, these are coming your way. People have complained about me, and they thought they were calling the right office. So, and then they called me instead. And I'm like, oh, okay, well, I'll tell my boss. Thank you. Oh. Okay, so we are now moving on to more and more things here. And Matthew Harden does a great job again. This is a very short notice here. But this is a notice that the notice of Russell Greer going to seek police reports and police actions against the farms and Null are frivolous. They note that the plaintiff's notice appears to have been frivolous that he previously filed, where he said that Joshua Moon had committed a felony and that after he meets with detectives, he is going to do something. They point out that he's made no good faith basis and appears he has not met with the detectives or provided a case number in almost 3 months since he made the scurrilous accusations that Joshua Connor Moon committed a felony. Once again, we're reusing the word, but that's okay. We're reusing the $10 word, but that's all right. That's $10 word. You paid for it. You should be able to use it a couple of times. It's like a reusable license. You get to use it. You get to use it. Yes, the felonious sneezing. Yes. So. Let's see here. $10 is a lot of money, yes. The sneedless accusations. I love that. I love that. I love that. Did Russell ever work in a law office? I don't probably as part of his paralegal training, he got to interact with them, but I don't think officially he did. So they point out instead the plaintiff confessed that he filed his notice for an improper purpose because it has been annoying. The plaintiff has repeatedly failed to identify any good faith basis, so they've attached the emails and the correspondence undersigned sent under Federal Rule 11 on March 26th. Uh-oh. Oh, no, chat. So we've got some emails now. We got some sub-emails. So this is, we're going to start at the beginning, chat. So Matthew Harden says, good evening, Mr. Greer. I wish I could do it in my Christopher Lee voice. There's Monsieur Scaramanga. Yes. Good evening, Mr. Greer. I write because I have not received your response to my email inquiry. Can you please provide me in the court, given your representations of the case number you proposed to provide back in January? And he says, also, I note that in an email to me on February 20th, you stated you'd be filing a sanctions motion against me. I have not received the motion. He says, I write to remind you it's your obligation to serve it on me 21 days before filing it with the court. When should I expect to receive it? And then Russell says, good morning, Mr. And Russell says, this is just a response to all of it. And then again, he says, later days, he says, I still haven't heard from you regarding my March 12th inquiry. You indicated way back on January 3rd, you providing the case number, referring to my clients. You haven't done so. Is there any reason for the delay? And then Russell says, sir, please only communicate with me on my Gmail account. The other email I had inadvertently contacted you on is a private email. Secondly, the case is a work in progress. I'd only informed the court because it had been annoyingly dealing with the harassing messages. Can you please explain what do you mean it's a work in progress? Did you make a criminal complaint and meet the detectives as you wrote in your pleading? Russell's going to be like, well, no. Yes, Mad Matthew, Fury Road, yes. Sar, you did not redeem your report with the constabulary, Sar. Oh. So, and guys, going back to this, if you guys don't remember, this is Russell's whole, the continuous stalking messages, from the farms, continuous stalking messages, and the intent to meet with law enforcement to pursue charges against the defendants. You know, he did all of this, and the continuously abusive messages. He said this is going to happen. And yes, as remember, someone called him a fucking gimp-faced, rust-hearted fuckstick. So, as he does this, it's been going on for too long here. This is not fair. These people are very vile, and Greer's hopeful law enforcement can track him down. What Josh Moon is doing is providing access to stalking. That's a felony. It's gone on for too long. And he'll provide the court with a police report after he meets with the detectives. So he did say all this. Oh. Yes, chat, I believe all those emails are as legitimate as any fake racist receipt you see, or a bunch of these. Oh, someone broke the window out of my Tesla, but there's no glass on the ground. They just went like on their window. Now, some Teslas are getting attacked, but a lot of people are faking it. So, Russell then went on to file. Russell did file this, and this is actually pretty funny here. He files a motion to extend. He needs time to file. He needs time to respond because he's been so busy. And he tells you what's going on here. So this is once again, chat. We're almost to the end. But this is so funny. It's so funny here. The plaintiff requests an extension of time for 2 weeks to reply to the excessive motions. Well, which ones? You're not saying which motions, Russell. Which motions? The deadline has passed to answer some of the motions. Well, that's a problem. Due to excusable neglect, plaintiff asked for a deadline to be extended. He says good cause exists. In the past 2 weeks, defendants have filed excessive amount of filings, ranging from the IFP status removed to accusing Greer of lying because the defendants are misrepresenting events. As Greer told Matthew Harden, this is not my full-time job. For a while, Russell didn't have a job, though, it sounds like. Greer is indeed trying to litigate this case to the fullest of his capacity. Well, that's a you problem, buddy. Due to the stresses of wife, Greer cannot offer his best response by the deadline to respond. Womp womp. Greer is a full-time student. I hope you can provide proof of that, claimed Russell. A full-time worker. I hope you can provide proof of that. And has been trying to research various legal arguments to counter the motions. For example, Greer just barely finished drafting a motion for sanctions for violating the SPO. That took 2 months for Greer to research. Because this is all new information to Russell Greer posted it again. Because Greer has not yet replied, Harden has threatened Greer by email to threaten to file sanctions for the pettiest of reasons. And we're going to get to that Exhibit A. Greer asked for a 2-week extension. So he's asking for time. Signed Russell Greer, my left foot. So what is it? Exhibit A. God almighty, can you just center things? Jesus Christ! Center them! Fuck! Center this shit. Was that Homestar Runner? Yeah, that's Homestar Runner if he had Mobius syndrome. Homestar Runner. Hello, Marzipan. You know. Trogdor! Oh, God. I'm Homestar. Oh, look now. I'm just a friendly reminder. Oh, yes. Verninator. Oh. Oh, there it is. Yes, I get this is so retarded. Like, I almost want to be like Gunnery Sergeant Herman. 5 fucking inches, pile! 5 fucking inches! All right, so what's Exhibit A? We have just blank fucking pages for some reason. So, Mr. Greer, I note that I have not received a response from my March 19th email. He says, therefore, I write to inquire. Is there any reason I should not file a request to submit for decision pursuant to Civil Rule 7.3, indicating you have consented to the relief sought? He's just pointing out, if you're not responding, can I just go ahead and say you consent? Is there any reason I should not file another motion for sanctions against you regarding your false statements that you did back in filing 213? Yeah. Gendravia says, I was raised by a cup of coffee. You guys don't get Homestar Runner here, yeah. Tim Pool says, I haven't heard Homestar mentioned in like 10 years. Meh. Well, it's funny you say that, and then right after that, the cheat. Just, meh. Oh. All right, chat. All right, so there you go. That's the thing. That's all Harden's just asking. Like, fucking give me an answer, brother. So Russell cries. So we're up to 264, and this is the opposition to the extension for time. So they come in and they say, and this is the arguments that you have to make. These are the proper arguments to be made by Harden. You know, he wants time for an extension, but he doesn't identify the motions. Like, how you can't do that? How do we, like, what? I need more time to respond to the things. Okay, what things? I agree. It's like trying to argue. Like, it's when a woman says, "Hey, can you get that thing for me?" What thing? The thing. Apparently, she's not listening. You didn't even hear me, did you? Nope, she's not even listening. Oh. So, with respect to any motion which a time of response has not yet elapsed, they take no position on the request. The good cause standard is highly flexible, and it's within the court's discretion to find good cause does not support the motion. So they say they have a partial opposition. Greer admits the deadline's passed. And with respect to the deadlines which have elapsed, they submit that Greer has demonstrated not only his ongoing and ordinary neglect in this case, but has not shown any excusable neglect by the meaning of the standards. Inexcusable neglect is 4 factors. You know, are you prejudicing the opposing party? The length of delay caused by the neglect? The reason for the delay, and it was in the control of the moving party. And the existence of good faith on the part of the moving party. And the reason for the delay is critical. It's the most important factor. Why didn't I get it done? And the ostensible reasons are the deadlines have passed because he was busy responding, and this isn't his full-time job and the stresses of life. Greer explains that rather than responding to the motions for which there was a deadline, Greer instead spent his time seeking sanctions against counsel for the imagined violations of the protection order. And that's true. Like, you had chances to ask for time back then, and you didn't. While Greer undoubtedly prefers to spend his time seeking sanctions against undersigned counsel instead of responding to pending motions, they submit to do so as not excusable neglect, but his own decision, an intentional, willful decision. Further, his pro se litigant status, who prefers not to spend his working hours advancing the litigation which he initiated, and which the defendants are forced to contend with, is not neglect. Pro se status does not constitute neglect for failing to file responses. The burden of neglect is even on pro se parties. So they're just trying to say they take no position on whether the court should extend the deadline for any motion, which is still timely. But for everything that has elapsed, they are opposed. And then also I love the little note at the bottom. Well, it's kind of like an addendum paragraph here. There's an additional paragraph. So they further note the motion is inaccurate insofar as it purports to state the defendants threatened sanctions against Greer for failure to respond. Instead, as indicated, defendants requested Greer to provide any reason a motion for sanctions should not be filed. And once again, this goes back to accusing Josh of a felony and stating he would get a police report. So, signed by Matt Harden. And we, like I said, guys, we are getting to things here. And there was another motion for sanctions filed by Russell Greer. He filed another motion for sanctions. And this goes back to, once again, chat, Russell is crying about the fucking protective order. Russell cried about the protective order. Because what does he want to do? He wants sanctions against Matthew Harden. Oh, I think Matthew went through like a fifth when he read this one, because this is scary. This was scary, chat. And real quick, chat, we got to address this here. We got to address this. Because somebody just showed up and did something great here. Whiskey 77 dropping 30 subs. And trust me, chat, I just didn't go like this and click on it 3 times. No, 30 subs, chat. That's right. Coming in, bringing the heat here, chat. And just making it known to Grays all over.
See this? That means not welcome.
Not welcome, Grays. Russell, you're not welcome here either. Keep moving. Keep moving. Keep moving. Thank you, Whiskey. Thank you for your support and your generosity. And he says, yeah, it smells less gray in here. Well, thank you. Thank you. And then, yes, make me laugh, fat man. My truck got hit in the truck stop today. Over 5K in damage. Oof. Oh, no. Did he hit your, like, on the sides of your, like, running boards and everything? Fuck up your tank and everything? Hopefully it was just cosmetic. Sorry to hear that, buddy. Sorry to hear that. And was it an Indian truck driver? You know, did he say, here, I can redeem you with Google Cards, saw? Oh, I'm sorry to hear that, brother. I'm sorry to hear that. Guys, Whiskey 77 3 Beers, they do Assholes React every Sunday night at 9:30 Eastern. Covering some good stuff out there, funny stuff. And once again, if you guys haven't gone over there, you can see them at Assholes React with the $. They have their breakdown of me and Nick Rekieta with the Ultimate Fight compilation. So go check them out. Go check them out. Oh, you got the hood, fender, and mirrors. Okay, well, that's not good, but I mean, it could be worse. Could be worse. Jim says that's welcome. Oh. Let me see here. Bodie says, I'm not welcome. Yeah. Base donator. Yes, very true. Good to see you, Richard Gruber. It's been a little while. With always the ever apropos AK Trump magazine. Keopathic says, nope, still gray. Suffer. Well, you if you want to revel in being a gray, I guess that's your thing. But I would never imagine being proud of being a gray. That's like, yeah. Yes. Unfortunately, I'm very racist towards the grays. I am. But you guys deserve it. You've earned it. So, we got to fix something here, chat. Hold on. Got to take care of something here, chat. Hold on. There we go. There we go. Hold on. What the hell? Why is this not working? Who is texting me? Oh, Hardin just texted me. Oh, what did he say? Yes, Matthew Hardin just wants to know. Yes, Matthew. Yes, sir. I am going to stream your disbarment proceedings. Oh, it's going to be great. I'm going to ask if we can actually have a camera in the courtroom. Yes, you're suffering, Mr. Hardin. Counsel will become legendary even in hell. You know, they will speak for years about your Russell's victory over you. They will speak of it for decades to come. Oh. Oh, here, chat. Need to fix this. There we go. All right. There we go. There we go. Had to fix a thing. We're all set. Everything's out where it needs to be. So Russell's crying about the standard protective order. And it says the defendant's attorney twice published unredacted information. Yes. And it was to torment Greer with the information and has left Greer worrying about the safety of his once proposed witnesses. Yes, the safety of people who don't want to fucking talk to you, Russell, because you're such a fucking tard. Plaintiff has simply wanted to proceed on the merits, but the defendants are insistent on getting Greer sanctioned over every mistake. Not every mistake, just a lot of them. It only seems fair, since the defendants are being so proactive rather than actual merit, that they too, yes, it is you who is going to be sanctioned. It is you for their mistakes through their licensed attorney, Matthew Hardin. So what does he want to do? He's talking about the protective order. So Russell Greer says the link provided does not work. And there are two competing SBOs, a pre-1223 order and a post-1223 order. Okay. There is a dilemma. This case has been terminated twice, so it's uncertain whether the pre-12/2023 order or the post takes effect. Not really. It doesn't fucking matter. But the fact you know there's two orders, Russell, shows you found it and you got a hold of it. And yeah. Notice you have the links to them. You've got the links. You went ahead and got the links, Russell. There's nothing here. Yes, the court entered an SPO. A copy was never given. However, he made a mental note that there was an SPO. Oh, he made a mental note. That's good. He made a mental note, chat. He made a mental fucking note there was an SPO. That's so good. I'm glad he made a mental note, Russell. I'm sure he would feel he make a note. And Siri's like, I can't understand you, brother. Greer was interested in the SPO because defendants run a website known for stalking people they dub lol cows. And they consider anything belonging to a lol cow fair game. Everything's fair game. Everything. Although there was an SPO verbally in place, no, there wasn't. Greer was still hesitant to hand over prospective contact information because Matthew Hardin made no promises what we do with it. Well, then what was there if you say you agreed to one, but also he's like, I'm not agreeing to that, then do you really have an agreement? No, that's not how that works. If you don't have an agreement, Russell, you don't have an agreement. So the inadvertent disclosure of public information. So, notice the defendants were not harmed by the 2-hour deadline. And this is the thing, Russell's rehashing all the shit here. Greer gave the phone numbers and names of witnesses. Greer inadvertently gave the information to Hardin without writing for attorney's eyes only. Greer did not write this because he was never given the copy of the SPO, and he didn't know how to use those words. Notice Russell say he didn't know how to use his words. Use your words, Russell. Use your words. Russell's like, I can't understand my words. Oh, I don't know how to use my words. It's so fucking funny. He's like, I don't know how to do this. Oh no, help me. Greer thought there was a blanket SPO in place and thought any disclosure was private. But Mr. Hardin knew that Greer wanted the information kept private and confidential. Why? Because the Kiwi Farms users have a documented history of stalking their targets. Further, the defendant should have known, based on Greer's response, that Greer feared the information being misused. Maybe Hardin couldn't understand you. Augusto Pinochet says, are we going over the job stuff today, or is that a future stream? No, we're going to go over Carl blowjobs probably. We have time tomorrow. It might actually be Monday because it needs its whole time. And Formula One, the Japanese Grand Prix, starts at 1, so we're not going to have time to get to it. So after receiving the information, Hardin impulsively filed his usual notice to the court claiming Greer wasn't complying. In the notice, Hardin did not redact their names. That since his plaintiff didn't have the SPO, he didn't know to write confidential information. Again, he assumed there was a blanket SPO in place, where everything was understood to be confidential, regardless of the designation or not. It seems that Hardin had purposely not redacted the information. I'm sure that was intentional. You fucking set yourself up for that. Yes. Roscoe is saying, why doesn't the Morin file a motion to make things confidential? He doesn't have to. If he indicates to Hardin when he's exchanging information it's confidential and for attorney's eyes only, that it should not be disclosed publicly and it's under the protection order, that's all he has to do. You don't have to file specific motions under seal or motions for protection. There is a blanket protection order, a standard protection order in place, but you have to invoke it. That's a very good question, though, Roscoe. Thank you. And a non-Robert L. McKim, Dr. Robert L. McKim Sr., Reverend Dr. Robert L. McKim Sr., Beacon Light Ministries, and of the CARES Radio Patrol. So Hardin is aware the Kiwi Farms audit has monitored this docket and thus would have been aware they would have seen the filing. Greer told Hardin, you violated the order by publishing the names and the phone numbers of witnesses. I told you in the court I didn't want published. After receiving the notice, Hardin made no attempt to remove his filing and uploading the redactions. A day after Hardin published the information, a Farms user contacted Greer and taunted Greer with the information, calling Greer a big dummy. But they didn't harass the... Notice, Russell never says they never harassed the witnesses. The December 29th disclosure of information. Hardin subpoenaed the once proposed witnesses. Hardin did not tell Greer he sought to do this. He doesn't have to. Greer told once proposed witnesses to fight the subpoena. You're literally admitting to like obstructing the court process here, Russell. And Matthew, I don't know if you're out there. I think you're watching this. I hope you're going to hammer on this because I didn't see these motions. Like I kind of read these. I'm kind of reading these new-faced. I try to stay off the farm thread as much as possible. He's admitting that he's obstructing things. Oh, my God. Oh, my God. Russell, brother. No, don't admit to violate. Like, don't admit to this. It's too late now. Oh, Hardin very impulsively filed his notes to the court and purposely published the email addresses of the once proposed witnesses. There's a December 30th disclosure. Hardin asked for an address so he could send a check to the plaintiff. Greer gave a Wyoming address, not because he was living in Wyoming, but it was a safe place Greer could receive mail, which would be forwarded to him. Greer lives in Las Vegas. Once again, he didn't write attorneys only because he was not aware he had to use those words. Once again, Russell does not know how to use his words. It's like talking to a child. Use your words. Use your words. So apparently Mr. Hardin had a problem with this honest answer and published the private address. Once again, the private address was not redacted, although Hardin should have been well aware the farm stalkers monitor the case filings. In that response, Greer pointed out Hardin published a private address. At no time did Hardin attempt to withdraw it. And all three disclosures posed a risk of harm to plaintiff and his connections. Because defendants are the world's biggest community of stalkers, according to who, Greer has been super nervous with handing over information because of lived traumas. The lived traumas, chat, his lived traumas. Dealing with the KF website. So Greer brings up he has a glitchy email. Okay, yeah, I have a glitchy email. Okay. Greer's been nervous the farms will harm his once proposed witnesses, either electronically or physically. It hasn't happened. Because Hardin disclosed and lied to this court that Greer was living in Wyoming, which he's not. I don't know if that was clear, Russell. Greer has learned that farms users will attempt to go to the private Wyoming address and harm Greer's family. Citation needed, Russell. You're going to have to back that up. And I think you should be sanctioned if you can't. You're now making serious statements that you have knowledge of upon information and belief based on what? This is a real fear, as the users have indeed been sending plaintiff death threats. And Moon's users have a documented history of doing this to other lol cows. So he's talking about the sanction standards here, blah, 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 blah. Don't do orphans. Don't do orphans. Control Enter. Next page. He talks about the notice, and he talks about the different orders. Gay, gay, gay. Gay, Russell. And the reasonableness expenses. The award of reasonable expenses, including attorney's fees. Well, you're not entitled to attorney's fees. You're not entitled to attorney's fees pro se. And the 11th Circuit, apparently you are. I learned that from Matt LaRossi, Floodbusters. But I don't believe in the 10th Circuit you are. So you seek a reasonable expense of $2,000 based on what? Based on what? Notice he thinks $2,000 is a reasonable amount of sanction. Once again, $5,000 is small and $2,000 is reasonable. But $1,000? Russell is just, oh my God, I can't pay that. Oh, no. Oh, yes, Bella, you're talking about the guy in the boat. Yes, that guy who jumped on the kid's boat got charged with burglary and assault. Multiple felonies. Couldn't happen to a nicer guy. The $2,000 is qualified as a deterrent to prevent future publications by Hardin. Greer does not believe an admonishment would suffice. But also remember, on April 1st, he then says, well, I want an admonishment. So Russell Greer goes, my left foot. But we have the exhibits. And once again, God almighty, not centered. Fuck me. Blank page. Maybe this is like a Taylor Swift, like, homage. That there's a blank space here and somebody can, write your name. So, and this is an email from Matthew Hardin saying, in answer to your comment below, I refer you to my November 19th email in which I stated I make absolutely no promises. What will we do with the information other than we comply with the orders of the court? Yeah, so there we go. He's like, I'm just going to I'm complying with the orders of the court. Make the court orders. This is, I don't know what happened here, but okay. And once again, we got just basically an empty page. We've got another basically empty page. And it says, Mr. Hardin, stop with your frivolous notices, sir. That didn't even allow me to reply before you filed that notice. You just violated the protective order by publishing the names. I told you the court I didn't want published. I'm a post-stage litigant doing my best trying to understand this. You are not being willful. I'm not being willful with anything. You are very pushy and jump to conclusions if I don't reply. I'm doing the best that I can. This isn't my full-time job. So simmer down, sir. Sir! Exhibit D. Yes, he says, even with a protective order, I have no guarantee he won't publish it on his site. Well, even if he doesn't publish it, we all can find it. You have even published our email communications, which has prompted his deranged neo-Nazi users to harass me. I clearly said in the documents there is nothing relevant this time. I have images in the emails of his users harassing me and the countless Instagram accounts harassing me that post links to the farms. But as you point out to the judge, that has nothing to do with copyright infringement. Thanks, Russell Greer. Russell Greer. So sad. So sad. You can send your checks to my address in Wyoming. Oh. And the New York Post. The writer swatted 47 times over a casual dismiss of Norm Macdonald, trying to destroy my world. Okay, but that's not the farms. I don't understand how that was linked to the farms, but that's a Torswats thing. The anti-trans stalkers at Kiwi Farms are chasing one victim around the world. Their list of targets is growing. And walking with poor Keffos. Lucas. Luke. You are a boy. You have a father, Lucas. Remember how that went? Remember, I'm platforming Kiwi Farms. Yeah, that worked out so well, Lucas. So there you go. Yes, Russell, showing people who racked up L's. That's a great way to make your case. All right, chat. So the farms asked for its motion extension of time. We already covered this. They're getting till the 14th. They want till the 14th to respond, and they are given till the 14th. But they do want a time to respond to the sanctions motions as well. So in this case here, chat, the sanctions motions are asking until May 2nd to respond. They're asking until May 2nd, which the court should grant. You need appropriate time. And they're asking, so it may be an appropriate cross motion under Federal Rule 11, which means they're going to cite Russell. They're going to sanction Russell. They're going to move for sanctions on Russell. And Hardin just needs more time. He needs more time, but it's only fair. Like, if we're going to have competing sanctions motions going, let's do them at the same time. Let's do it live. So, yes, Hardin did left side alignment here. It's not justified. It's infuriating. But we all can't have what we want, chat. So, yeah. So, you keep moving. I do love this from Hardin here, though. This is when Russell says, Russell wrote, "Please expect my sanctions motions forthcoming." He's really threatening. He's like, "I'm serious. I'm going to do it. I'm also filing a complaint with the Virginia Law Licensing Board." And this is where he threatened to have Matthew Hardin's law license revoked. Your conduct is unbelievable. So you don't deserve to be a lawyer. But if you want to go hard, let's do this. So I love Matthew's response. "I very much forward to reading your motion. Be sure to serve it on me 21 days before you file it as required by Rule 11. And then he says, "Also, just remember, filing frivolous bar complaints is itself sanctionable, and I will, of course, take appropriate action." And that is true. Unfortunately, it's part of your pattern, as a other lawyer in Nevada figured out. Yep. I'm surprised Russell hasn't tried to grieve me, which I'm surprised. Not saying to do it, Russell, but I'm surprised you haven't tried it. Or if you've tried it, they just screened it out and they never told me, because they don't always tell you when they screen shit out right off the bat. So interesting what you're going to do, Russell. Interesting what you're going to do there. So the court, as of April 3rd. So notice we're caught up, chat. We finally reached the promised land here. The court's done some things. So the court has a decision and an order here. Let's see. Where are... guys imagining me as a judge? No. Anyways, they're talking about the sanctions against Joshua Moon and Matthew Hardin, and the defendant's motion for an extension of time to respond to this motion. The court has reviewed the parties' written memorandum. The court concludes the oral argument is not necessary, and therefore decides the motion on the written memorandums. For the reasons explained below, Russell's motion for sanctions is denied. So the motion for extension is rendered moot because you don't need it. So the parties indicated that this case would involve the disclosure of information and other material that will be designated as attorneys or eyes only. Therefore, the court found good cause existed to enter the court's standard protective order, which is affected by operation of local rules, and entered in the scheduling conference. In December, Greer provided the defendants with the names and telephone numbers of yet-to-be-disclosed witnesses, following a court order to do so. Greer states he inadvertently turned over the information without indicating it should be attorney's eyes only. under the SPO because he was never given a copy of the SPO. And he was unaware to formally designate as confidential or attorney's eyes only, which is what you have to do. Instead, Greer says he believed any disclosures would automatically be private and confidential. Well, they're not. And if not, the defendant should have known. Greer wanted the information to be kept private and confidential. And the court does make a note here. As mentioned, the SPO does not need to be entered to be effective as is enforced by operation of local rules. It is accessible on the court's website. Although this case was filed in 2020 because neither a schedule nor protective order were entered until 2024, the SPO that applies is the 2023 one. So notice the court's just like telling him to fuck off here as we go. So after Greer sent the names and phone numbers, the defendants filed a notice arguing it was deficient because Greer had not provided any information there. The defendants attached to their notice a copy of the email with the names on there. Greer contends it's a violation of the SPO. Greer also argues a Hardin violated in later filings by publishing the email addresses of Greer's witnesses and identifying the wrong address. Accordingly, Greer wants sanctions for violations of the SPO. Now, the sanctions, regardless of whether or not, and this is the best part, chat, whether or not Greer marked it confidential or attorney's eyes only, it does not qualify for this kind of protection of the SPO. Under the SPO, a person who produces documents or information may designate them that, but there's a special thing for it. You have to have good faith belief the information is a trade secret, non-proprietary, confidential technical information. It's scientific, financial, business, health-related, or medical information, including health information under HIPAA. That's the shit that's confidential. Additionally, you can designate attorney's eyes only technical information, manufacturing information, patent prosecution information, sensitive marketing information, identity suppliers, distributors, customers, technical specs, technical analysis, comparisons of other products, business analysis information, marketing strategies, strategic planning, anything else that would cause harm if it was disclosed to the public. Notice none of that is here. The names and phone numbers of witnesses are not confidential, so they are not a trade secret or anything else listed. And they're not subject to attorney's eyes only because it's not sensitive technical business information. The same analysis applies to Greer's Wyoming address that was disclosed. Therefore, it doesn't fucking matter. Therefore, even if he had done so, the court finds it would not qualify. So accordingly, he gets recated and denied. Sorry, Russell. And the court also notes that contrary to defendant's assertions, Greer's motion for sanction was brought under Rule 37, not a Rule 11. Therefore, the defendant's argument Greer is required to serve the motion for sanctions 21 days before filing is inapplicable. So a little bit of a felting there, but not really a big one, but a technical thing. So still Russell, suffer, Russell. You lose, you lose. Then finally, there was one more order, chat, that was put out. There was one more order. And this is regarding Russell's time to respond. Russell required time to respond. He wanted a 2-week extension of time to respond to the motions. And because Greer seeks to extend deadlines that have already expired, the court must consider Rule 6. The rule provides that the court may, for good cause, extend a deadline after it's expired if the party failed to act because of excusable neglect. So Russell has to show both the good cause and the excusable neglect. They talk about the 10th Circuit, and they talk about good cause and neglect are not identical, but are interrelated. So they say good cause shows a greater showing than excusable neglect. Good cause comes in the situations where there is no fault, excusable or otherwise. So it requires the moving party to show the deadline cannot be met despite the movement's diligent efforts. So to determine the lesser standard of excusable neglect is shown, you have to do 4 things. We already talked about it. The danger of prejudice to the other party, the length of the delay and its impact, the reason for the delay, and whether there was control of it by the movement, and whether that movement acted in good faith. And the third factor is the most important. So the court looks at whether or not Russell Greer can establish excusable neglect, and it says he can't. As to the first factor, the defendants fail to identify prejudice that was result from granting the extension. And the court says, yeah, because they didn't do it. Okay. And the court cannot see how any prejudice would occur if it were to allow Greer 2 weeks to file his responses. Even if the court extended the deadline, the pending motions would still be fully briefed for the motion hearing set on May 6th. For the same reason, the length of the delay will not impact judicial proceedings. The second factor. So I know, guys, right now you're like, uh-oh, wait, this isn't good. Be still. Be still and calm. If you're like, oh, I don't like this. They say, however, as to the third and most important factor, Greer has not provided an adequate reason for failing to timely respond. Greer states only this isn't his full-time job, and he wasn't able to respond to the deadlines due to the stresses of life. Additionally, Greer states he was unable to do so because he was drafting a different motion. Moreover, Greer has proven time and time again that he knows how to file a motion with the court. He easily could have filed a motion for extension before the deadlines. Yes, and he could have, and the court has granted them. Courts will liberally grant you more time, even for Russell. He could have stopped and said, please give me more time. 1-page motion. Bam, out, done. And the court would have said, sure, here's more time. But he waited. This factor alone makes his failure inexcusable, as failing to work on responses was entirely within his control. Rather than responding to a series of motions already before the court, Greer chose to spend time drafting another motion, which the court denied within 4 days of its filing. And also, contrary to his assertion, his pro se status does not constitute neglect. Although the court sympathizes with his stressors and responsibilities, Greer appears to be juggling as the plaintiff in this lawsuit. Mr. Greer is responsible for prosecuting the case. It's your fucking problem, which includes responding to the filings. Thus, to the fourth factor, there's no adequate reason beyond his control for missing the deadlines. Because demonstrating good cause requires at least as much as what is required to show neglect, the proffered explanations above are insufficient to show that failing to meet the deadlines was not within his control. For that reason, you are recated, Russell Greer. The court is tiring of your bullshit. And we are now caught up. As I said, chat, we're getting to like the part of, it's kind of like, how do you go bankrupt? Slowly, and then all of a sudden. I think that's kind of where we are with Russell. It's like watching guys felling a tree. You guys ever seen somebody cut down a tree? If you've ever cut one down yourself, you get in the back and you make your cuts. You make your notch, technically your humble cut. And you sit there, you take a couple of wedges, you pound, and then the tree starts going a little bit, then bam! And hopefully you don't barber chair. That's where we are. I think it's starting to happen. I think we're at the part the tree is starting to fall. It's got a long way to fall. It's going to take a long time to fall. But I think it's going to start happening. I think we're at that point. The court's like, we're not fucking dealing with this. We're not starting to deal with this. Yes, the edges of the felt, you're starting to be able to see through the piles of chips, chat. Russell's stack is getting shorter and shorter. So, yeah, Greer took advantage of the court for too long, and now he's going to suffer. He's going to suffer. So, I think that's where we are. We're not at the beginning of the end, but we have accomplished the end of the beginning. Which, when Winston Churchill said that, it was like 1941. So we still had a lot of World War II left to play, guys. There was still a lot of time. There was a lot of time left on the clock. A whole lot more people needed to die. And in this case, a whole lot more notions are going to have to get filed. So we're not there yet, but we're getting there. No, it's not the beginning of the end yet. Augusto Pinochet says yes. The 7th Army is still standing. Mein Führer. Yes. Oh, actually, wait, hold on. When did he say? End of the beginning. The beginning of the end. Winston, Churchill. Winston Churchill. When did he say that? It was a 1942 speech. After the... I'm sorry, chat. It was after the Battle of El Alamein. I thought it was in 41, but it's after the second Battle of El Alamein because there were 2 battles of El Alamein. The first one really wasn't good for the Allies, but it was the second one a couple months later where things changed quite a bit. Things changed quite a bit. So, yeah. Yes. So, that is where we are. That is where we are. That's your free history lesson for today. So, gonna drive those crowds and spigs out of North Africa. Yes. The Allies called him Mulligan. Well, that was the route to get to Cairo and Alexandria. So, so let's get to some of the comments that were here. We got to catch up on some things. Nate Matthews, this is why I was doing the whole thing with Baked Alaska. Yes, we love our crops for fertilizer. We love our crop rotation. It's important. Yes. Joshua Fisher says, we love our spics, our citrus pickers. We love our migrants till they get deported. Oh. The Chugi Show says, late. Can someone ask Mama Criminal to text me to get a move on? Thanks. Yeah, she doesn't follow this stuff. She's not really interested in these things. She's like some of the internet stuff. She's like, I don't really like that stuff. And I'm like, that's okay, Mom. That's okay. You don't have to watch all of it, but she clicks on it to give me a view. But she's probably not listening tonight. So it's okay. Richard Gruber says, bailiff, reattach the plaintiff's foreskin. It's circumcised him. I'm surprised that these judges are not ordering that as part of things. You know, Trump must recircumcise these people if something happens to them. ED references Mr. Rogers over here with the sweater. You know what, though? It's comfy. It's nice and warm. 2.0 says, I look like the Unabombers. We got to do something about it. Joshua Fisher says, we love our grays, our new viewers. We love our algorithm. It's important. I mean, I'll agree the algorithm is important. And yes, if you guys are grays, I don't hate you. I'm disgusted by you. But no, thank you all for being here. I do truly appreciate it. Brewberry says, a member for 14 months. Thank you for the support. Says, I requested the matching sweaters in the chat before. And I know there's like the other thing you guys have going on, and I know she's there, and I'm sure you guys all hatched your plan. So, but yes, thank you for the message. EDW Raptor's been a member for 19 months. And chat, I know not all of you can afford to do the memberships all the time, all those things. I understand money is issues for some people. So for those of you who are out there, you've been here forever. I know who you are. You know who you are too. You know, still nothing but love for all of you guys out there. It's just humbling. It's humbling to see these numbers. It really is. I don't know if you guys understand that, but at least to me, it's very humbling to see numbers like this. Yes, matching sweaters for your dog is gay. I mean, I guess. You know, letting Aaron eat your goo is pretty gay, though. Trump one says that the Ohio Bureau of Workers' Compensation keeps getting the same info wrong. Is there anything the filer can do? I don't know. Because you're basically like, you're just going to have to keep correcting it until you like that. That's the only thing I think you can do. I'm not really sure. Sorry, I can't give you a more clear answer than that. Jefferson Post says, I'm not vexatious. I also can't produce all my lawsuits. Yes, thank you. Stephen Bunt says, wait, what? I thought Russell's case has no merit. How could we possibly shake it Harden? This should be easy street. How could Harden be at risk? Yes, like I said, I think it was a joke. Unless you're joking too, which in that case, I couldn't pick up on the social cues, and we're just all retarded. But I also understand I probably didn't portray that properly earlier. Alyssa says, I'm behind, but the matching sweaters with Clyde is the cutest thing I've ever seen. Yes. Yes. Jefferson Post says, Sean likes giving advice, but Lyle Cow's got to pay. Yes. Jefferson Post says, so is his paralegal in suing the farms? Is the farms? That's an interesting way of putting it. Who's worse, Greer or Carl Jobst? Carl's worse because Carl's not a retard, and Carl fucking lied and scammed his people out of a lot of fucking money. Like, he clearly defamed Billy Mitchell, and Billy Mitchell is a massive piece of shit. But Carl wrongly defamed Billy Mitchell and fucking doubled down on it and got people to give him money, saying, "Oh, he's a cheater, cheater, my Donkey Kong." Like, it's fucking pathetic what he did. Carl deserves everything coming his way. You know what? Here's the thing. Eventually, he's going to be known as Carl Blowjobs because that's the only way he's going to be able to pay it off. He's going to be an absolute legend in the dick sucking community, I bet. Elegant News says, if songs and books are from Fiverr, does he have the copyright as Russell did not produce them? Yes, the people who do it, if you go into Fiverr or any of those things, part of it is you can negotiate with that party to sign over copyright and they can relinquish their claims to it. Nat Close says, am I going to the Steel Toe anniversary? Not sure yet. Not sure yet. Got some things I'm trying to sort out logistically with my schedule. Will Aaron be able to afford 2 seats? I don't know. Maybe Aaron's just going to pay for, like, he'll call up like FedEx. And he's like, can I just borrow one of your freight planes? And they'll strap me to a pallet. I don't know. I don't know what he's going to do. Ron over on Twitter. Thank you, Ron. Says, don't mind me. Just the token Zitter Ghost. Well, thank you, Ron. Guys, you can find him over on Beer for Breakfast, guys. They're doing a podcast. They're doing a show in the mornings here on YouTube. You can find them over there. It's pretty good. Sometimes they're super early too. But you can find them over there. Thank you for being here, Ron. Then Seekalother for 10 Singaporean dollars. Good to see you, man. Says Greer is suing based on copyright infringement. Do you think there is any merit to his case? Remember, it's contributory copyright infringement. No, there is no merit to this case. It's absolute fucking horseshit. I'll play devil's advocate. As horrible as his music might be, he did create and copyright them. I understand that, but I kind of, like I said, I just, like, he paid somebody to do it. I don't even think that happened. I think the guy just fucking AI'd it for him. So, but yeah, thank you for the super chat. Thank you. Jefferson Post says Russell the Bunny Rancher versus Josh the Farmer. Yes. Squizgar says in Spartan culture, Russell would have been left in the wilderness at birth. No, they would have thrown him off the cliff. Patrick H says for $5. Well, to be fair, a lot of cultures would have just left him out in the woods to die. Patrick H says, thank you for being here, Patrick. Says his idea for his next book, How My Addiction to Prostitutes Torpedoed My Copyright Lawsuit. Yes, that would be funny. Brad says, have I ever had to tell a client to fuck off? Yes, I have. Anderson Cooper says, what about Stepan Bandera? Well, fuck all the holes. Fuck the Ukrainians. So no, I have no love for them. So they can all fuck themselves. Even though he was trying to do the right thing, it sounds like, when he was working with the Germans. No, fuck the Banderites. They can all go to hell. I hope they all catch a Fab 1500. So, Pink and Hef says Sean Martin version 2 is screwed. Technically, he's actually been an attorney longer than me. Can we use a name potentially criminal nigger killer? No, please don't. Oh. I hate Yankees for $5 says Russell's brain problems are as bad as his face problems. Oh, they're even worse. He's just completely retarded. Edward Scott says Nick Rekieta is green. Don't be like Nick Rekieta. Oh. Jim tells you how you doing. Jim says hopefully he didn't need a cock medic. Oh, Jefferson Post says, I'm only worried when the Grays rebrand wearing Feldgrau. Yes, that is my concern too. But until then, they haven't. Schneebly says law school is 3 years. Yes, some of us take a little longer, especially you go part time all the way. It took me 5. But yes, Russell Greer has been suing people for 10 years, and he is as stupid as a day one law student. Day one law students are still smarter than Russell. How is this possible? Because he's a tard. He doesn't learn. He doesn't learn what he does. Jefferson Post says, as a judge, I would hold hearings on formatting. No, but I probably would put in my local rules. The court prefers you to do things certain ways because I'd be the fucking judge. Roscoe says Russell goes hard R all the time. Yes. Stephen Cooper says gabagool. Thank you. Also, Stephen, I saw your news on locals. Congrats on retrieving some of your guns from the burglars. Congrats on that. Then Schneebly is a new member joining up to fight the Grays. Doing his part, chat. Absolutely doing his part.
Fight for the future.
I'm doing my part.
I'm doing my part.
I'm doing my part.
I'm doing my part too.
There we go. Just doing his part, joining in the fight. Making America green again. That's what we're here for. Making America green again. Bamala says, didn't Hardin originally try to set up a depot in Wyoming because he thought queer lived there? No, he set up the depot in Wyoming because Russell's dad lived in Wyoming. Yes. Patrick H. Yes, this is... Yes. War never changes. For 4 years, this has gone on. Let's see here. What about Ryan Cannell happened? Did I miss something? What about Ryan Cannell? So anyways, I don't know what he did here. Yes, 2 hours till Formula One. It's going to be fun, chat. We are going to go over to locals and watch over there. You can join us. So Patrick Ace says, come on, Russ. File a motion. How about you know how to do it? Okay. Shit lips is seething. Yes. Well, it just happens, you guys. It just happens. Sweet Bovine says, I wonder if we can get Russell Greer to hook up with Cobes in Casper, Wyoming, if you know what I mean. I don't know what you mean. Sorry. Unlike Gloston says, I enjoy when judges issue opinions on lawyers' writings. P6 says, are you buying the dip? It's not really going to be a dip because a bunch of countries in the European Union's like, sorry, we'll give up our tariffs. Fucking mission accomplished. Sometimes taking your fucking big old meaty cock out and shoving it in their face, be like, you really want this? And Europe's like, no, we don't want that. It's too beaucoup. It's too beaucoup. A lot of the world's going to beaucoup. Mission accomplished. So, let's see here. Where, okay, Anderson Cooper says, I like how it's so out of context now. Sean didn't reply about using it in the Zoom chat. Yeah. So, the ball's on the table, yes. Oh, you guys are just talking about random shit there. Okay. I was concerned Lego was going to get more expensive. Well, a lot of the stuff they're claiming, but now it's all like everybody's backing down and we're going to get to like no tariffs. Great. Let's do some real fucking free trade. So there we go. Let's go, America. Let's go, America. Fucking golden age, chat. 1,000 years. That's right, 1,000. So, are you going to stay up for this F1 race? Yeah. Yep. Yes. So, I think we're all caught up here, chat. We got that done pretty good time. We got that done a pretty good time here. as I said, I think Russell, get ready. You're gonna have a lot of crying coming up. I still can't wait for Russell. I want to hear Russell on the record because we've heard him in the Ariana Grande stuff when someone went in there and recorded it. It was just beautiful to go through. So you're looking forward to the Carl Job stream. Like I said, if not tomorrow, we'll do it Monday because Carl needs to be dragged for being a piece of shit. P-Dub says the model stream. Well, last night, because I got done with the mock trial stuff real late, we started working on, and this is so cool, guys. I know you guys are getting annoyed by me talking about it, but one of the people in chat, Jolly Jake Level, sent me this, and it is the coolest fucking thing ever. It is this. This is a 1987 model kit. What this is the MiG-37, and the MiG-37 is what the model companies were imagining the Russian stealth fighter program was looking like. Because in the early 80s, the Americans thought there was the F-19, and it was this sleek SR-71 looking thing. Although, funny enough, if you look at this, they thought this is what the Russians would be able to do. This is more in line. Look at what it is. This is actually more conceptual to, what America ended up doing with like the F-117 and the Advanced Tactical Fighter program, which gave us the F-22 and the F-35. This is actually more conceptually along the lines of that than the F-19, which had these sweeping lines and curves. This is slab-sided, like the F-117, like the F-22, like the F-35. I'm sure they took from the Firefox thing here too. But this is also like what they thought was coming. So yes, it's the YF-23. Yeah, but the YF-23 wasn't classified at the time. And that was just a drawing in 1986. So we're working on that. It's really neat. It's interesting. It's got different plastic. It's got different level of detail. So even the instructions are super cool. So I'm going to keep, this is definitely what I'm keeping the box and the instructions for. Territory says, when is Nick's court date? The 18th. The 18th. Bella says, I got to go. Tornado warning. Be careful, Bella. Be careful out there. Hope you're safe. Be well. We'll see you over in the race. Project Wingman stream when they recently just updated it. Okay. I'm going to sound like a casual here, but what is Project Wingman? This looks like an Ace Combat kind of thingy. I've never heard of Project Wingman. What is this? Oh my God, I might like this here. Let's see what this is here. What is this? We're going to, I kind of like where this starts off. Project Wingman, here we go. Thank you for bringing this up, Patrick. It's a love letter to Ace Combat. Well, hey, there's nothing wrong with that. Made by fans of Ace Combat. You have my fucking attention, good sir. Is there Strigan team? Because that's the coolest thing. That a fucking flying aircraft carrier, a bunch of fucking flankers come spilling out of in tigers, like red tiger stripe. But here we go. Let's check a look at this.
Enemy aircraft shot down! Go! On the way!
We've got hostiles. Moving to engage. We'll put back a few more.
Okay, yeah, this is 100% Ace Combat. This is 100% Ace Combat. But I like how we were using a Century series. That was pretty cool. That was pretty cool. That is something I never thought I'd see in a game like that. That is interesting. That is very interesting. I give that some points right there. I give that some points. That was very, very cool. That was very cool. Which is kind of like an F-106, but it was like a 2-engine F-106. So I don't think you'd call that the F-102 had like a bulbousy canopy, but I don't know. I don't know if that would be the F-106 or the 102. But I mean, it's basically the same thing here. But let's take a look.
Bandit shot down.
This is pretty fucking intense. I like it.
Ground target destroyed.
Ooh, you could be a frogfoot? Nice. Get your SU-25 on. As we're learning from the Ukrainian conflict, it's a very underrated airplane. It's been proven its weight. Ooh, Super Hornets. I like that. Nothing wrong with the Super Hornets, but we're not doing which is good. Got the Super Hornets with the right in tanks. Oh, is that really what I think I just saw? F-15 actives? Guys, these are like, this is the F-15 active program. This was an experimental F-15 that never, that flew, but was never, they never did anything with. And also it's an F-15 that they were preparing, they were going to conceptualize with like F-22 thrust vectoring. But with the front canards on it, that's so cool. Got a bunch of fox bats getting refueled.
Target hit. Bandit's mine. Hostile taken down.
They're still going. Let's finish it.
Well, it wouldn't be Ace Combat without a massive aerial boss to shoot down, so that's true as well. I fucking love the F-15, yes. Pull up the image of that frogfoot that's cut up like Swiss cheese. I don't think I've seen it before, so I don't know which one you're talking about. But yes, we're seeing in Ukraine the frogfoots are just getting, like, surviving quite a bit of damage. And they're flying the wings off them on both sides. So, yes. Chaff flare. Oh, yeah, we have one of those too.
Chaff flare, out, chaff flare, low, jammer.
Oh, that's that was really cool. That was the Avro arrow. I don't think. Oh no, I don't think it's the arrow. That was not the arrow. Is it? Oh, it is the. Wait, it's the arrow because it's got. Is it? Did I fuck that up? Oh, it's got two engines. Yeah. Yeah, that is an Avro arrow. Fuck! God damn it, you guys got me on that one. Bitch, son of a bitch. Yeah, that's the Avro arrow. Fuck. Good catch. Good call. Good call. So. But I'm going to need a joystick and shit, and that means I'm going to get ended with a sim pit. Which means I'm going to get the F4 DCS, which means I'm going to lose, like, I'll never work again. So, no, we can't do it. I got to be careful. The Arsenal bird is the goat, yes. Well, no, not the Arsenal bird. Oh, what do they call it? The Agion. In the Xbox Ace Combat, where the Strigan team came flying out the back. That was the coolest thing. That also was the big weapon was the railgun. The Estavakians had Project Chandelier to take out the asteroid that hit. The F-15 actives were NASA test beds. Yes. So fucking cool. If you guys have never seen this thing before, this thing is so fucking dope. Look at this motherfucker. This is it was a flight demonstrator. And it's notice it's the first two-seater, and it was the sixth F-15 off the assembly line. It was the oldest flying F-15 until it got retired. It was also the avionics test bed for the F-15 Strike Eagle program. But this is what they wanted to do with it eventually, was with some thrust vectoring. So it would have F-22 style nozzles. That's just like an artist's conception of it, but and notice you can see that it's the serial number right here is 71 means it's fiscal year 1971. So that's when the funding was approved for it. So that's when it's built number. But that is the aircraft. This thing did all kind. And that's the neat thing. Like DARPA and a lot of the flight testing NASA did, like the F-15 active, the X-29, the X-31. We did a lot of cool shit. Like I said, the ATF program, the Advanced Tactical Fighter program that was going through the late 80s, throughout the 90s, there was some cool shit out there that was being developed. You know, like you could look at the X-31 and aside from the thrust vectoring, you'd think you're looking at a Eurofighter Typhoon. Like there's all kinds of neat shit out there, chat. And there was a lot, like the end of the Cold War, like late Cold War aviation was super fucking cool. It was super cool. So, yeah. The Avro arrows in the game. Okay, there you go. It's sad I messed up. Yeah, clearly the plane knowledge isn't as good as your train knowledge. Yes, I'm a fake plane autist. Oh. The main campaign is fighting the UN. Based. The DLC is you playing as a reservist fighting off the country, fighting the UN. Okay. Get head tracking for DCS. I can't... Guys, I would never fucking do anything if I got DCS. I can't do it. I can't do it. Post a link from Reddit with the frogfoot being towed away. It's under your latest Greer post. Oh, is it on okay, hold on. In locals, let me see here. Okay, here, hold on. Are you talking about on like Twitter or where? I don't know where I'm looking. Keep simping for the ATF again, such a flopper. Remember the Comanche? Yes, that was a cool thing too. I can get you cheap head tracking. I don't need head tracking. I don't need DCS. I can't do it. DCS is Digital Combat Simulator, which is like some of the most accurate, and challenging flight simulators out there. It's on X. Okay, I'll check on X. All right. Okay, well, that's where, because I don't know. Let's see here. What is this? People are tagging me. Okay, let's see. Profile. Oh, I see it now. Okay, here we go. All right, this is from the Reddit, but it is worth watching. Okay, guys, so this is somewhere in Russia. This is an Su-25 Frogfoot. Basically their version of an A-10. A brutally tough ground support aircraft. Getting hauled out off a runway. Getting transported after it got damaged. So here we go. So here's what we got. So look at this thing. It got chewed the fuck up. And if you guys this is actually very catastrophic damage for airplanes. That thing got fucking lit up. Ooh, buddy. Ooh, buddy. That's definitely, that's surface air missile damage. There's some ground fire probably, but all these little holes and jagged shit, guys, I don't think you understand. When a surface air missile goes off, it doesn't contact the airplane. Right outside right when it gets close, it explodes and it basically shotguns a bunch of material into the aircraft to destroy it. Because hitting it is not going to be as devastating. It's like a fragmentation grenade. So, but yeah, ooh, buddy. Got sliced and diced. So there you go. That's some good battle damage. That thing might... I don't know if that's going to be a write-off, but that's going to be out for a long time unless they got a lot of cannibalized spares they can pull from. Looks like there's frame damage on the spars and the wings. It looks like inside the frame there's damage. Like, this is going to need a lot of work, but it's still something they can probably work on. But given the amount of losses they suffered overall, if the airframe is still salvageable, they have to salvage it. So, There you go, chat. But yeah, tough old fucking airplane. Tough airplane. Pretty gnarly. Those engines are fucked 100%. A disintegrated engine in the fuselage is catastrophic. Sean thinks you're all retarded children. I don't know if people know. Not everybody knows everything. So did that make it back, or was that crashed and recovered? It doesn't look like it crashed. It looks like it landed. The Su-25 does it can sustain a lot of damage itself. So, Sean needs motion tracking for his VTuber future. No. All right, chat. So we are all done for the night. We are all caught up. Thank you all for being here. Did I see the HIMARS strike on an airfield? No. Send me the link to that. I'll take a look at it, but I have not seen it yet. So, but yeah, guys, we are all done for the night. We are going to watch the Japanese Grand Prix tonight over on Locals. Join us over on Locals chat. Potentiallycriminal.locals.com. It's promo code WHIPIT. Get 1 month free access. Japanese Grand Prix. What time? I think it's 1 o'clock. The Grand Prix is set for 1 a.m. our time, Eastern time. Max has the pole. McLaren is 2 and 3. And then we got Ferrari number 4 and we got Mercedes number 5. So it's going to be interesting. We got Antonelli. Antonelli did a very good showing as well. He's 6th. So we got some good stuff, chat. We got a spicy top 6 there. It'll be very interesting. The first turn is what they do and what happens there. So that'll be at 1 o'clock. We'll see you guys then. Yes, use promo code WHIPIT. But other than that, chat, thank you so much for being here. Russell Greer, it's gonna look bad for him. But in the meantime, chat, I will see you guys. And remember, until next time, just because you did it does not mean you're guilty. Except you're Russell Greer. Fuck him. Fuck Russell Greer. He could suffer all day long. I have no sympathy for the man. He needs to suffer. That's all he's good for anymore, is just to suffer. Guys, if you're down in Alabama and Arkansas areas, you're down in the South, watch yourselves. It is getting shitty out there. But take care, chat, and we'll see you guys later. Good night.
Weapons, blacksmithing, and models of planes, esoteric works, and even some trains. Much merriment had while drinking White Claws, tips on hunting, and even talking the law. Whatever you do, just don't talk to cops, even when they nab you on illegal stops. Just 'cause you did it doesn't mean you're guilty, but please talk to a local attorney. Was that the fat guy Rick hated yelled at?